Inclusion. Give the inclusion slip. Give the inclusion slip, sir.
I don't matter. Under the heading of new motion, it is related to pensionary benefit. I am ordering. I am challenging the last order which has been passed by the CAT by a single bench.
Yes. What do you want?
I want to challenge the last order CAT which has passed by with a single bench. It is never been heard by this honorable court, my lord.
You want to challenge? Who is stopping you? What do you want? We are unable to understand.
For inclusion of new.
Give the. You said give all the inclusions. Yes. Motion. Get it listed. Get it listed. It's a new motion. It's a new motion. Maybe a date has been given. On that date.
Item number 1.
My lord, in this matter, my lord, I appear virtually for the Union of India petitioner. But on the last occasion, your lordship heard this matter. But this is relating to the second original application filed before the CAT by the respondent, who paid for interest on the delayed payment of recovered amount. On the first round of litigation, the recovered amount was directed to be paid. Accordingly, as per direction, we have paid the recovered amount, about 4 lakhs and odd. That has been paid. Now, in the first original application, the respondent never paid for interest. In the second original application, the respondent paid for delayed payment of the recovered amount from the pensionary benefit. Now, the CAT has allowed the original application, the second original application. On the last occasion, your lordship wanted to know from me whether rules permit to pay interest on the delayed payment of recovered amount. Now, we have found out the relevant rule in this regard. My junior is present physically. She is handing up the rule. Your lordship kindly consider the rule and decide the original application. This is the 1958 death cum retirement benefit rules. But only thing which I found from the rule that administrative lapses has to be there. Now, in my humble submission before your lordship, I don't find any administrative lapses because the respondent was paid erroneously the EOL for the period of about 10 months. Now, that was subsequently detected and recovery was made. And as per direction of the learned CAT, Central Administrative Tribunal, we have paid the recovered amount. In the second original application, the respondent paid for delayed payment of the recovered amount and the original application was allowed. Thereby, we are aggrieved.
Deduction was on what ground?
Since you have delayed to pay the recovered amount, so pay the interest. That is the direction. But
no, why recovery was required to be done? On what ground?
Because 10 months EOL was paid erroneously to the respondent. 10 months EOL, about 4 lakhs and odd. That was subsequently detected that
10 months?
Extraordinary leave, which does not entail any salary, but salary was paid for 10 months. That
extraordinary leave amount was encashed for 10 months.
Yes, that was paid erroneously, subsequently recovered. As per direction of the Central Administrative Tribunal, we paid the recovered amount.
Where is the order passed in OA 714?
Page 30.
Hmm? And which provision in the rule that you are saying that administrative lapse can only justify grant of
Lord
interest?
19A. Lord 19A, your lordship kindly peruse rule 19A. That is the only provision made in the rule of 1958 that interest can be claimed or paid, Lord, if there is administrative lapse. Lord, in my respectful submission, Lord, the erroneous payment of any kind, Lord, cannot be construed as administrative lapse.
And this recovery was made after her retirement.
Yes, from the pensionary benefit.
Tribunal has granted how much interest? 7%.
But it is also hit by constructive res judicata. In the first round of litigation, she never paid for interest. It is hit by constructive res judicata.
No, this res judicata will apply in against a statute. The Payment of Gratuity Act says that if it is an administrative lapse, it has to be done. Therefore, this not come in the way.
So, Lord,
Point is whether there is an administrative lapse or not, that is the issue.
right, that is the issue. And another thing, Lord, why I say, Lord, this is hit by constructive res judicata, because, Lord, estoppel or res judicata cannot be, Lord, applied in case of statutory provision. I understand. I bow down to your lordship. But thing is this, Lord, that when he prayed for recovery of we prayed for, Lord, the payment of recovered amount in the first round of litigation, he never claimed any interest. He could have prayed for interest along with recovery. She did not. She did not.
What is the prayer in the OA? Earlier OA is the earlier OA on record.
Page 23. Page 23.
23. And you did not make any submissions before the tribunal? Nothing. You have not said anything before the tribunal. Only applicant has made submission and that is all.
Right, Lord, right. It's correct.
You did not file a reply also.
No, because Lord, at the Lord, first instance, the Lord, original application was disposed of granting the relief. But one thing your lordship kindly appreciate, the
The amount is 529,363. Recovered amount?
no 4 lakhs and all, Lord, 4 lakhs and all. 4,15,000 or something like that. And Lord, kindly appreciate one thing, Lord, the amount which has been paid, which was recovered, which has been paid as per direction, that was also unjust enrichment, I must say.
That was also?
Because unjust enrichment. Because she was never entitled to that amount.
Given in has never been challenged. Yeah, right. Now they are seeing that just capital and then it could not be recovered. Because post-retirement was to be done as per the CCS pension rules, which has not been done. All right. Third learned senior counsel for the
My lord, item 2, I am for the respondents and I am the applicant in the before the learned tribunal. My lord, we are also challenging the order of the learned tribunal. We are also filing it. My lord, I am praying it that both the matters be taken up together on the next Thursday.
Have you filed it already?
Well, today it is being filed.
We are informed by the learned counsel for
To the court of for tagging.
once it is filed, you mention it, it will
Fine.
be, we'll get it listed along.
Great.
Item number 3. In this matter, my lord,
Yes,
my lord, the final relief has been granted by the tribunal in interim nature. Main prayer of the applicant before the tribunal was to disburse salary for 3 months, my lord.
3 months.
3 months. And my lord, on that particular day, learned advocate who appear on behalf of the railway, he prayed for time to file the reply and to take instruction. But my lord, that interim order passed with the direction to release the salary for that period. My lord, thereafter, my lord, the railway filed review application that was also rejected. Now we are before your lordship challenging
Both the orders.
both the order. My lord, kindly see the last page. Last page, that is the main order passed in the tribunal, my lord.
In the
That is the order dated, my lord, 13th of September 2024, my lord.
Lordship, on last occasion, Lordship, direction was passed to file a affidavit disclosing some documents, Lordship. Affidavit is ready, Lordship, but as the father of the respondent is expired, Lordship, that could not be affirmed, Lordship. On that ground, Lordship, praying for 2 weeks' time.
how much time?
2 weeks' time.
Payment has not been made yet. Have you complied with the order? No.
My lord, particularly only this protection, my lord, not to, my lord, take any steps against the officials if they file the contempt petition or like that.
What is the direction in the order? Let us. 30th September. Yeah. What was the claim? Claim was for 3 months salary only. And that is the only due.
Let's kindly see the prayer, my lord.
The sum and substance of the submission advance on behalf of
4.
Sorry,
My
instruction.
lord, I am for the petition, my lord. And this is an application, my lord, for extension of benefit of the order passed by my lords, my lord, in respect of other co-petitioners. The present petitioner, my lord, could not join in the original application in the WPCT before this honorable court, my lord, because of some difficulty. Subsequently, he made an application for addition of party, which, however, was withdrawn as the then bench, my lord, was not inclined to add substantively as petitioner. Yes, ma'am.
And what happened in 119?
119, my lord, was pleased to pass an order. I have handed over, my lord.
Already disposed of.
Yes, yes. Disposed of directly, my lord, that in terms of the order passed in WPCT 88, the person concerns, despite being disqualified in fate, should be appointed.
And by humble submission, I have received instructions. In all other matters similar in nature, where the liberty was given to the respondents to submit an affidavit. Kindly permit us 3 weeks times to submit an affidavit disclosing the fact. But there are four types of orders passed by the honorable division bench. 4 different benches have passed different orders.
So he is right now, he is seeking you have filed
Relief?
an application.
My lord, the substantive WPCT I have filed, my lord.
Oh.
Because, my lord, that
Separate WPCT.
separate WPCT, because, my lord, that application for addition of party was not allowed.
He is seeking relief similar to the relief granted by your lordship in WPCT number 119 of
And,
2023.
my lord, I cannot be, my lord, treated differently
Following
because
No, we had asked you to find out whether he was a party to CP number 40 of 21.
yes, but I have
Yes.
that I have handed over.
I have also searched out.
But,
He was party to CPC.
He was.
He was.
All right, then he must have an opportunity to file his reply.
Was an
The learned counsel for the respondent fairly.
I have submitted. I confessed. Yes, I inquired.
Just, you don't listen. I have just now
That has been
recorded
recorded.
that he has given instructions that he is, upon instruction, he submits that he was party.
can a different stand be taken in this matter?
Huh?
I am asking unto myself. Because I was also similarly placed. They were disqualified in fate. I was
Why do you waste the time or your time and court's time? They are filing opposition and you are making argument. What is the point? Pointless submissions for no purpose.
submitting
Call the
after
next
5
case.
times. This affidavit is being sought for by the learned counsel.
This is,
This is 5th time. After 5th time, my lord, they have prayed for this affidavit in opposition.
give the records.
Finally, because my lord, adjournments were taken. Only, my lord, adjournment, even on last date also. Last, on the last occasion, you got to file.
Affidavit file group.
There are only 2 adjournments earlier.
No,
Yes.
other adjournments were simply adjournment because he was.
Call the next case. You are just unnecessarily wasting the court's time. Yes, call the next case.
Five.
Lord, in 5, my lord, I beg to appear on behalf of the appellant. I'm for the response. Lord, earlier it was hard, my lord, on 6-5, my lord. Lord has directed us to come up with the guideline which is guiding this, my lord. I will repeat the fact, my lord, because it is long since. एसएन डॉक्टर लिखे दें
So typing test and suitability set test are two different things.
two different things.
So he did not participate in the suitability test.
He could not. Because in the meantime, Milord was superannuated.
He retired, and in the meantime, you did not conduct any test. Both is
In
true.
the meantime, we did not conduct. After
But he participated in a typing test.
participated in the typing test, he qualified for that. But this is only one of the criteria. He has and must have to pass the written test. That I have the criteria has been annexed at page 34.
Page
34. Page 30.
he is to become senior clerk from which post?
Yeah. But 34, first one, my lord. On this, in the seventh column, my lord. Non-selection, seniority, suitability being judged by the seventh column. So it is the criteria.
Page 34.
My lord.
Yes.
Milord, the first column, Milord. Milord will find out senior clerk.
Yes.
Then, Milord, these are the things which are required for class, protocol, and all this. Milord, the seventh column.
Non-selection posts. Seniority.
Suitability being judged by
So he never qualified the written test.
Lord. Earlier he qualified, but thereafter he failed on the second occasion, and on the third occasion when he could not appear because of the superannuation.
So once he participated in 2005,
Once he participated in 2005.
but he did not want to leave the station, so he forgone the result. Second time, when did he participate?
He participated, my lord, on the second time, my lord. My lord, he was given a promotion. He denied second time department notice. He was transferred, my lord. Unsuccessful, page 26, my lord.
26.
Page 26. Pindokule, typing test. No, my lord. This is not this one. The my lord, I apologize, my lord. Succeeded for promotion and denied transfer department. Successful, page 25.
Give us the date. Give us the date.
Page 25, date, my lord, 13/10/2006. Page 25. Number 1, my lord, is Govindokule, the respondent herein, my lord. Have your lordship find out?
He was found unsuitable.
Sir?
He was found unsuitable. So
he could not qualify.
So he could not qualify. He has appeared twice but qualified once.
Once. Earlier,
But this second time he has appeared, it is also of 2006.
2006. 2004 he appeared. He qualified, my lord, given a chance, transfer promotion, he denied it twice. So, my lord, he was debarred. And he had to give again the suitability test, which on the second occasion he was not successful. Thereafter, my lord, on the third occasion, my lord, he appeared in the typing test. He though qualified in the typing test, but could not.
To his benefit.
No, because
it lapses. Is there any provision that?
Yes, my lord, the provision is there. My lord, the guideline for these promotions. My lord, 2, if the denial is
Yes.
guideline. My lord, it kindly comes to clause 9, my lord. My lord, 9(1)(an). My lord, will I read it?
Yes, we have got it. Yes. Anything else?
Lord, this is the reason, my lord, he was not.
Yes.
My lord, the guideline, the lordship may kindly come to paragraph 6, my lord. Suitability test numbers to be called continuation, supplementary test, interval, etc. 6.1. Suitability test, may I read out, my lord? Suitability test should be held after a gap of not less than 1 year. All eligible staff, including those who failed in the earlier test, should be called. Period of 1 year is reckoned from the date of announcement of result. The number of eligible staff called for consideration should be as per para 4.1 above. So, my lord, every year, suitability test is held every year, my lord, after a gap of not less than 1 year, my lord. So, my lord, since 2006 to 2010, 2015, my lord, no suitability test held. That my learned friend can answer, my lord. If at all held, my lord, I was not called for.
2006 to 2010, no suitability test was held.
That
Is
may
there
be, my lord.
is there any application representation made by you that I am desirous of appearing at the suitability test? Have you said anything on this to this extent in your OA? Let us
My
see.
lord, in the original application, the facts
In
of
the OA, that is what we are saying. In the OA,
but in the original application, no, my lord, no such representation has been made, my lord.
have you stated that you could not appear because no exam was being conducted?
No, my lord, I was never called for. I was never informed also. I am totally kept that, my lord, my learned friend did not even ever on affidavit ever.
We are asking you a simple question.
Well.
You are raising a plea that you were deprived of your opportunity to appear, though you were desirous of appearing.
Well.
This stand prima facie appears to be unsustainable since you have foregone a promotion because you chose to be at a particular station.
Well.
Therefore, we are asking you to establish your bona fides based on the pleadings made in the OA that after 2006 you wanted to participate and you have made efforts. Show us.
I have never made any such
Then
representation.
what submission you are making and how do you how such a direction can be issued? Just read para 12. What is the meaning of the order?
Well, lord, when I was-
Consider the applicant. First, the tribunal says consider it, and if he is found suitable, then what is to be done? Nothing. Otherwise, he should be granted the benefit of. So, if he is not found suitable, he should be granted the benefit.
No, that should not be, my lord.
Just read the order, sir. Can anyone make head and tail out of this order?
That in my
Were qualified as senior clerk and he was given that provisional OA.
You consider to that extent, we'll modify the order. The tribunal has directed to consider, you consider. With whatever order you have to pass, we don't know. But
My lord,
this
in
para
my
12
lord,
is
my lord, may kindly consider one thing on page 47, my lord, of this petition, my lord. It is a
Yes.
submission made in my original application, my lord.
yes.
My lord, may kindly come to page 47, my lord, internal page 4 of the original application. In 2005, my lord, I had been promoted, my lord, from junior clerk to senior clerk upon being successful, my lord.
Hmm?
I had made, my lord, at that time, my lord, I made a representation that I may be considered for posting at Howrah, my lord. It was not considered, my lord. Thereafter, I had joined in Kharagpur in compliance of that promotion, my lord. But when I joined at Kharagpur, my lord, thereafter I was even not given that promotion.
You can join after 5 years.
My lord, not 5 years. My lord.
Why not just one day prior to your retirement, you go and join pursuant to that order passed
No, no.
5 years earlier?
Lord,
What kind of
I
submission you are
joined
making?
thereafter, my lord. I joined thereafter, my lord. When I was denied.
Where are these facts? Everything in your head, or we have to see it from the records?
But this answer lies in page 20.
Side by side argument. We asked you whether you have anything else. You said no. Now
No, I have not.
everything is submitting. You are making some submission in between. The basic.
I have to take some instruction as to
No,
the
sir.
date
No
on which
instruction.
I had
Sorry.
joined as a in Kharagpur.
Take down. The
Item number 7.
আগে চতুর্বেদী আর তার আগে চতুর্বেদীতে চতুর্বেদী আমার না আমার
Competent authority, vague or by an incompetent authority. What else?
I tell you, Lordship. Today my submission, I shall give reply to a lot.
No, no, we asked you to come with the judgments. Ah.
Chronologically, I shall present. Today, I shall commence my submissions on the point that the judgments and order which was delivered by the lauded tribunal was erroneous on 4 grounds. Two grounds I have stated yesterday, that the entire finding that directing the authorities to de novo the disciplinary proceedings, and by the way of the judgment, the tribunal was pleased to set aside the entire charge sheet from the stage of charge sheet till the end of final order of the punishments, including the appellate authorities order. So entire proceedings, that means de novo means from the initiation of the charge sheet. My respectful submissions today before your lordship, this judgment is erroneous. But when charge sheet can be quashed, that is the issue now.
That is why we asked you to come with judgment on the issue. That is why we said that as far as I remember, ambiguity of the charge or issued by an incompetent authority.
At first, kindly consider 2012. 2012 to the 2012 volume 11 SCC. Paragraph 4 onwards. First of all, the Honorable Supreme Court in these judgments laid down the propositions that paragraph 4. I shall start from paragraph 4. The legal propositions has been laid down by this court while interpreting the provision of Article 311 Constitution of India that the removal and dismissal of the delinquent or misconduct must be by the authority not below the appointing authority. However, it does not mean that the disciplinary proceedings may not be initiated against the delinquent by the authority lower than the appointing authority. Now, 5, 6, 6 is relevant. 5, 6 different judgments have been laid down. Okay, come to 8, para 8. And the different judgments of law has been relied on. Para 8. The law does not permit washing of charges in a routine manner. In case the delinquent employee has any demands in respect of the charge, he must raise the issue by filing a representation and wait for the decisions of the disciplinary judge. In case the charge sheet is challenged before a court or tribunal on the ground of delay in initiation of proceedings or delay in conducting the proceedings, the court or tribunal may cause the charge sheet considering the gravity of the charge and all relevant factors involved in the case, weigh all the facts both for and against the delinquent employee and must reach the conclusions which is just and proper in circumstances. Various judgments are placed reliance. So therefore, after then 10, 9 is not relevant. 10. Ordinarily, a writ application does not lie against the charge sheet or so-called notice for the that does not give rise to any cause of action. It does not amount to an adverse order which affects the right of any party unless the same has been issued by a person having no restrictions, competence to pursue. A reply when some right of the party is impeached. In fact, charge sheet does not impeach the right of the party. It is only minor order punishments or otherwise adversely affecting. A party is passed, it may have a demands and cause of action. Thus, a charge sheet or so-called proceedings should not ordinarily be passed by the court. Then Brahmo is July 12. 11 is not 12. Does the law
So incompetence of the authority, a very belated charge causing prejudice. These are the best, not only belated causing prejudice.
prejudice causing prejudice? I appreciate it.
And
And
thereafter
not without jurisdiction.
incompetent authority.
The jurisdiction. Without
These are the two reasons.
So here,
The third, there is also one line of judgments which say that if the charges are ambiguous, then also it is liable to be.
right, I have. But in a given case, my lord, the case is in hand or lordship. Yeah, my lord. If your lordship kindly consider the OA applications as a whole, there is no such pleadings that alleging that the charge sheet itself is vague or without jurisdiction. Or
Has he sought the relief of quashing of the charge sheet?
no such relief has been claimed, no pleadings has been made. But and also, my lord, the tribunal has wrong. By passing this order, my lord, that the cost for quashing of the charge, because no such finding on it also. No prayer, no pleadings, and no findings.
Findings are there, my lord.
Therefore, my lord, my humble submissions, my lord, these portions of the order should not stand, and also subsequent. For the subsequent, my lord, I want to develop my submissions. My lord, I shall place reliance on my lord, B.S. Chaudhary. But let me conclude this part also. Already, my lord, as I appreciate, lordship has got to the point that when charge sheet can be quashed. My lord, only one judgment, in addition to this Supreme Court decision, our High Court 2000 report in 2011 SCC online Calcutta 5617. This is a single judge.
This is a later judgment of the Supreme Court.
Why I'm saying? So, I'm not saying that this is binding on your lordship. But only thing, my lord, the ratio resident I want to rely on. What has been decided? Only resident, last two paragraphs. Everything on the similar case like para 20 and 21. Only resident, I shall rely on. As indicated above, the disciplinary authority have inflicted the punishments of removal from service on the basis of the allegations for which no definite article of charges were framed, and thus the order passed is not satisfactory. Thus, the order passed by the disciplinary authority as well as the appellate authority and revisioning authority are hereby quashed and set aside. Next paragraph. Since the inquiry authority has restricted its finding on the article of charge framed by it, it would not be proper to quash and set aside the entire disciplinary proceedings. The disciplinary authority is directed to make a de novo inquiry, and the entire exercise shall be completed within.
This is not required. If the grounds for quashing a charge sheet are not made, charge memo is not made out, then there is no question.
No question of setting it aside. Second point, my lord.
This case, it appears that the conclusion was of the authority was holding a misconduct which was not part of the charges.
Not found in the charges.
So MV Bijlani case is there, Supreme Court judgment on this point. MV Bijlani case.
MV Bijlani case is also.
Yes.
So I have come with that also, Bijlani.
You have come with that.
Yes, 2006, 1994.
In MV Bijlani, it was that case that the inquiry authority had traveled beyond the charges.
That is the point. And that Bijlani also relied on.
But that is not applicable. Here it does not, that does not apply. Here the question is whether the charges can be assailed or set aside. Then what are the grounds? These are the 2-3 grounds. If none of these 2-3 grounds are made out, then charge memo may not be quashed.
In another judgment, 2012-11.
Why? For what purpose?
For the same purpose.
Don't multiply. You have given. Why do you want to give 10 judgments on the same?
I want to place it on record. 2012 volume 11 SCC.
This is 2012-11 SCC.
Oh, very good.
Yeah, that's why we are saying you have already given. Yes. Yes.
Now I will land on one decision of Supreme Court. There is a larger bench decisions. That is BC Chaturvedi.
On which
I am challenging the entire order. My humble submission on entire order was wrong.
Yes, you said you said 10-4 has been violated.
10-4 has been violated.
Yes.
and not entire order should go because
So tribunal is bound by 10.4.
tribunal is bound by 10.4. This is the regulations and rules.
Tribunal is bound by 10.4.
Because it's the guiding rules and the rules.
The tribunal, the authority conducting the inquiry is bound by 10.4 and the procedure therein.
Should at least give respect to the rules. Unless there is a contrary view taken or the contrary stance
The
taken.
tribunal has a larger jurisdiction to, it is in the nature of the jurisdiction which we exercise. This is established now by L. Chandra Kumar judgment. They perform a supplemental role. Therefore, to say that their discretion is circumscribed by the 10.4, which is a jurisdiction available only to the inquiry officer.
Only
How
to
can?
And 10.4, proviso says,
Yes.
if court of tribunal think that is a fitness for de novo inquiry, and from what stage it will be points. That is the mind.
No, that does not.
From which stage?
Please read again.
Yes, yes.
It does not direct or in any way the court's jurisdiction is not circumscribed. It says if the tribunal directs, then how the authority is to implement it. It does not deal with the court's jurisdiction. It cannot.
No, I'm saying it cannot, but it is the guideline which has been or rules.
Please read 10.4, what it says. It does not say that the tribunal has to do a thing in a particular way. It says if the tribunal directs, then how the authority is to implement. That is what it says.
Once again, 10.4 proviso, provided that no such further inquiry shall be ordered.
Yes.
Unless
By whom?
by the authority.
Obviously, yes. Not by the tribunal.
Unless no, I'm not saying.
Yes.
Unless it is intended to meet a situation
Yes.
where the court passed an order purely on technical grounds.
Yes.
Without going into the merits of the case.
Correct.
Here, my stand, the tribunal has gone into the merit, not on the technical issue demanded back.
Yes.
And directing for proceedings.
So this part does not apply.
This part
Does not apply.
on this part.
This part will apply only if it is quashed on technical grounds and then sent back. So this part does not apply. Now read further.
Tribunal was the interdisciplinary proceeding.
Mr. Counsel, this part is dealing with the how the order is to be implemented if the tribunal quashes it merely on technical grounds. But this does not apply here. It has not been quashed on technical ground. That is what you are submitting.
Yes, my submission
So then what does it say?
not was from technical ground.
Yes.
It was on merit.
Yes. So this does not apply.
If it is on merit, then the further enter.
So what does it say? What does it say regarding? Yes.
Proceeding, but it's not required. But 4. Let me place the enter 4, subparagraph 4. Then exception, proviso. Where a penalty or dismissal or removal or compulsory retirement from service imposed upon a government servant is set aside or declared or demanded while rendered void in consequence of by decisions of the court of law, and that the Supreme Authority, on a consideration of the circumstances of the case, decides to hold a further inquiry against it on the allegations on which the penalty of dismissal, removal or compulsory retirement was ordinarily imposed. Ordinarily imposed. The government servant shall be deemed to have been placed under suspension by the appointing authority from the date of the original order of dismissal, removal, or compulsory retirement, and shall continue to remain under suspension until further order. Then provided that no such further inquiry shall be ordered unless it is intended to meet a situations where the court has passed an order purely on technical grounds without going into the merits of the case. My humble submission, the tribunal is wrong. It's an erroneous point. The tribunal decided the inter issue on merit, not on technical if it has been demanded by quashing the inter proceedings. So my humble submission, no.
So for that, how 10.4 comes if it, that is what we don't understand. 10.4 is dealing with how the authority is to consider the issue when the tribunal sends it back. That does not govern the tribunal's jurisdiction. You may say that the tribunal's findings are erroneous, it is perverse, that you may say, but not with reference to 10.4. 10.4 doesn't cover or govern the tribunal's jurisdiction. Then if it does, then we will also be guided by 10.4. Peculiar submission is being made.
Now, my humble submission, the next point is this, that the tribunal has set aside the entire
Tribunal has set aside the entire proceeding that we have already seen in detail how it has been done. We have read it and you have also read it. We have also read it. So we have seen the inquiry report. There is no material whatsoever. Nothing. 2 witnesses out of 7 perhaps. 6.
Out of
They,
these
2 were examined. One was examined halfway. The other was examined full. He has said nothing but the fact that I found these things in his almirah, in his locker. And on that basis, you hold all the 4 charges proved. It's a perverse finding prima facie.
Then kindly permit me to relax on another judgment.
Yes.
Where on the same issues.
Yes.
And that is one actually. Based on record, whether inquiry proceedings could have been conducted. Yeah, in a given situation or based on record. We have received complaint on 13 reported in 2013.
What is your submission before you give?
In view of this, in a given situation, how did the disciplinary proceeding authority or the inquiry officer proceeded with the inquiry? When the inquiry officer received the report, based on the report, there was no complaint was admitted, but the complaint was not in there.
He was not in the even listed.
Complaint was not in there. In a given Supreme Court, the similar fact, the complaint was not in there. But from the complaint was outside. Complaint, the disciplinary authority received the complaint in writing and placed before the inquiry officer. Based on the recorded document, the inquiry officer had proceeded with and prosecution witness was examined, the findings and thereafter one of the delinquent officer did not turn up, ex parte inquiry was proceeded and order passed. Our case is similar to this. The Supreme Court said in 2013, no need of. If the delinquent had chosen not to participate in the inquiry proceedings and the inquiry officer proceeded on the basis of the record.
You are relying on K.C. Rahi judgment.
This is Narendra Kumar Pandey.
It's on the same point. Deemed waiver of the compliance with principles of natural justice.
But in our case, at least 4 or 5 occasions the delinquent officer turned up. Suddenly he has chosen not to participate in the inquiry proceeding and the inquiry of paragraph 20 and 23. Relevant. So it starts from paragraph 20. I'm sorry, 20 onwards. 20 onwards.
Just give us a minute. Yes.
The tribunal was wrong in deciding on the government. But my next submission, kindly send us the enter order and want the matter to the tribunal for adjudicating arbitration.
Where is the inquiry report?
Page, my lord. Starts from page 97.
Yes, filed is written the statement of defense. Where is that statement of defense?
Page 104. Start from 104.
No, this is his representation on the inquiry report.
In one inquiry. But he has submitted. Defect.
No, we have seen he has submitted, he also appointed a defense representative.
Yes.
Where is the statement of defense?
For a moment.
Yes, yes, take your time. Okay.
way. So, but I send my client to get it within 10 minutes. Within 10 minutes.
Inquiry officer has considered it, but he has not considered. He has not taken note of anything from the written statement of defense.
Article chart number 1 is concerned. Got it. Based on the bank's transaction, etc., the charge could have been established. This is on record.
What are you reading? Article of charge number 1.
What was the allegations? Kindly consider what was the allegation and how.
The presenting officer in his brief has given reference of all documents enclosed in the charge sheet, which includes the bank transactions printed out and statement of AGS and statement of AGS. This is his statement. AGS is the petitioner.
Statement of petition. Yes. Payment of rupees 50,000 by complainant. It is on record. TFT transfer. Copper 13 report.
Payment of rupees 50,000 by Subinay Kar. He is the complainant.
He was the complainant.
He is nowhere, my lord.
Subinay Kar's statement has also not been considered.
My lord. And my lord, he has not even listed as a prosecution witness. Yeah, he is required.
Please. Yes. Subinay Kar has been, did he submit any statement also?
No, he submitted complaint.
He is after complaint, he has not done anything.
No further documents. Not required.
So he has set the ball rolling. His allegation has set the ball rolling.
Yes. Obviously. Got the ball rolling. We got the sheet. Yes. এবার এটা তুমি আমাকে পাঠাও তাড়াতাড়ি করে আমি এটা জজ সাহেবকে পড়িয়ে দিচ্ছি এখান থেকে হোয়াটসঅ্যাপে পাঠাও সেম প্রবলেম এসে গেছে We got the tip on our defense. That way.
So this, even if this statement is accepted, no, because in the trial, in the inquiry, at best, if at all, it can be relied upon in respect of article of charge number 1. How it can be relied upon for 2, 3, 4, and 5? See what he has said. For 2, 3, and 4, this will not cover. He says, I have taken money. I have taken money under some compulsion. I have told these persons that I will return the money to them. All this I have done outside the factory. The office is not at all involved. Insofar as the other things being recovered, he has denied it. He has not admitted to that. Recovery from his locker and all that. He has said, no, I got a duplicate card issued because my card was lost. There was some stamp which belonged to my his some relative which were lying with me. So therefore he has not admitted to the, even if this is an admission. We understand what you are saying. Therefore we are saying, even if this is an admission, at best it can be an admission for the article of charge number 1. How you have held 2, 3, and 4 to be proved? It says nothing in respect of 2, 3, and 4.
One article of charges has been proved. So one of the proceeding stands. Even on charges is proved. Therefore, allegation stands. And three also call letters. That pre-employment medical call letters, because he used the rubber stamp, showing that doctor
Never used the rubber stamp.
should appear before the medical.
No, regarding other charges, there is nothing in this. You have not relied on anything other than this statement of ASG. Every charge you say statement of ASG or AGS, whatever it is.
Assisted. Yes. Nonsense stuff. Everyone will actually goggles.
AGS.
AGS.
That is delinquent.
Is delinquent.
Yes.
Therefore, the appreciation of evidence was not but in exercise of judicial review.
No, where is the reappreciation of it?
The tribunal has gone into tried to examine all the evidence. What is the evidence? How could it prove the charges?
That is not reappreciation.
And
That
the
is
documents relied on.
that is trying to find out whether there was any material. That is a different thing. Reappreciation of evidence will be that the evidence is to be read in this way.
Analysis of evidence and how it is to be placed.
They are asking you what documents you have relied upon. Even your inquiry officer says that the presenting officer has placed so many documents. He is not here for giving his defense. Therefore, this does not weaken the allegation in any way. This is his finding on all the charges.
Try to supplant his own views, substitute his own view while passing of this order. That is not that.
No, see, before you make these well-established propositions, you have to show the facts. Where is this fact to support this submission that you are making? Where is his perception on which issue? You are making submissions which are established principles, but this is not born from the fact.
One paragraph you have already seen.
Yes.
That for the nature of allegations are concerned, without initiating disciplinary proceedings, could have registered FIR and the criminal proceedings could have.
That is not an expression on the charges. That is not expression on the findings. That is a completely different issue.
Observations and that has also been recorded.
We are asking you, when you make a submission that he has given in his own perception, where is that own perception? There is no perception. That he cannot do, everybody knows. The law is well settled. But these propositions have to be applied to facts which occur in the case. That is not the case. Only one ground which prima facie we are in agreement with you regarding interference with the charge memo on the ground that it cannot constitute a departmental proceeding. We have, at least speaking for myself, I have never seen such a finding that it cannot be a departmental proceeding and it has to be a subject of only a criminal proceeding. How it can be? Even if somebody has beaten up someone in the office, it will constitute both. It will be a criminal offense as well as a misconduct in the office. So therefore, on that issue, at the moment, subject to what he says, we are in agreement. But on the other issue, apart from AGS statement, there is nothing. And the entire records you have said in regarding findings regarding article number 1, you have said that all the documents have been placed. What are those documents? Nothing. The presenting officer in his brief has given reference to all documents enclosed in the charge sheet, which includes bank transaction printout statement of AGS. Which document has been read by you? What you have deduced from that document? Nothing. There is no consideration of the material. What is the statement of the AGS? Even that you have not said. It's total non-application of mine. Yes.
My lord.
Regarding charge memo, what is your submission?
Kindly peruse internal page 12 of the judgment, para 13B, my lord.
Para 13.
13B. Charge sheet against the applicant is based on complaint dated 11 July 2015 from 1 Sri Shubinoy 4. The statement of imputation of charge for all the articles of charge makes it clear that the charges framed against applicant are based on the written complaint dated 11 July 2015 made by the said Sri Shubinoy Court. Further, the complaint dated 11 July 2015 of Sri Shubinoy Court has been listed as serial number 1 of the list of documents by which the article of charge framed against applicant were proposed to be sustained. However, the applicant was not allowed to inspect the said complaint dated 11 July 2015 made by Sri Shubinoy Court. Further, Sri Shubinoy Court, the author of the complaint dated 11 July 2015, was not produced as a witness by the prosecution during the departmental inquiry and was therefore not examined and cross-examined. This is a serious procedural lapse since Sri Shubinoy Court is a vital witness on whose allegation the disciplinary proceeding against the applicant has been initiated. The Honorable High Court at Kolkata in WPST number 300 300 of 2010 decided on October 1st, 2010 in the case of Chaudhary versus State of West Bengal has held as below. On examination of the records, we find that vital witness, namely mother of the not examined. A desperate attempt has been made to establish the charges against the prisoner in absence of vital witness. In the present case, we are satisfied that non-examination of the vital witnesses has initiated an inquiry procedure. Has vitiated, actually it should read as vitiated, man. Has vitiated the inquiry procedure. Further, the Honorable Apex Court in the case of Messrs. Electricity Supply Company Limited versus the Workmen and others, reported in AIR 1972 SC 330, has inter alia observed that when a document is produced in a court or tribunal, the question that naturally arises is it what are the contents and are the statements contained therein true? If a letter or other document is produced to establish some fact which is relevant to the inquiry, the writer must be produced or his affidavit in respect thereof be filed and opportunity afforded to the opposite party who challenges the fact. In Rup Singh Negi versus Punjab National Bank and others, reported in 2009, 2 SCC 570, it has been held as under a departmental proceeding is a quasi-judicial proceeding. Performs a quasi-judicial function. Charges leveled against the delinquent officer must be found to have been proved. The officer has to arrive at a finding upon taking into consideration a detail brought on record by the parties. The Evidence Act may not be a proceeding, but the principles of natural justice are, as the report of the inquiry officer was based on merely ipse dixit, as also surmises and conjectures, the same could not have been sustained. The interference drawn by the inquiry officer apparently were not supported by any evidence. Suspicion, as is well known, however high may be, and under these circumstances, sufficient for legal proof. My lord, and also another point, my lord, kindly peruse the charge sheet. My lord, kindly peruse page 26 for a moment, my lord.
Yes.
My lord, first paragraph, middle portion. To unveil the truth and investigate.
Page 26.
Page 26, my lord. First paragraph, middle portion, my lord. To unveil the truth, an investigation was carried out on 17th July 2015 in Security Office by Vigilance Officer of Gun and Shell Factory, Kashipur, Sri R.K. Sinha, Joint General Manager, in presence of Sri Shantanu Shah, Joint General Manager. The said Sri Ghrai admitted during the course of investigation that he had taken a total of rupees such and such only from 16 outsiders, including anyway, my lord, now, my lord, the investigating officers, that is Sri R.K. Sinha, Joint General Manager, and Sri Shantanu Shah, Joint General Manager, they have also not been listed as prosecution witnesses. So, charge sheet is vitiated, my lord.
Is there this service is governed by CCS?
Yes, my lord. CCS rules.
And where is the charge memo? This is the charge memo. And there is no list of witnesses.
Page 106.
Hmm.
No, page 28.
Page 28 also.
So R.K. Sinha and Shantanu Saha are not there.
Not there, man.
The document is at page 106.
Page 27.
It's actually there.
27. Well, দুবার annex হয়ে গেছে।
And these documents have been given to him or only list has been given?
What for document?
No, this is a list of documents. But whether these documents have been given to him, this is a list. This is a list which says that these are the proposed, these are documents proposed to be sustaining the charge. But there is no because he has asked for these documents.
What for description of the document?
No,
That page.
on 26/2/2016, the AGS has written to you that I will not participate unless you give me the documents.
But he had participated 5 days.
Earlier.
Right, correct. That we are not saying. We are saying he refused to come unless you gave him the documents. So the option available to you was that come and inspect, we will not give you because our rule does not require, or to give him, or to say that the document you are asking is not relevant. You have done anything or you have not? Because the presenting officer was going to give his brief on 20th March. Before the presenting officer submitted his brief, he asked you to give him documents on 26th February and he said, unless you give it, I will not attend. Thereafter, whether document has been given to him, that we don't find from the inquiry report. There is no such mention.
Repeatedly asked for, man.
Huh?
That has been repeatedly asked for.
Yes. Inquiry report's date is 4th of June.
What date?
Inquiry report 4th of June perhaps. So in February he asked you for the documents. In March he submitted his brief EO, and in June the inquiry report has been submitted. In between, the inquiry report does not record that after that you have filed a WS before the tribunal. This is your WS. Where is it? At which page? Reply, page 148.
To the tribunal.
Just see page 148.
That is reply to the MA, not to the way.
So this is so it must be just before that. Then it must be just before. This appears to be the only reply. Is there any other reply? This is the reply. They have dealt with the averments made in the OA. No, perhaps this MA has been written by mistake. This is the reply.
I submit the so far the documents annexed to the charge sheet. Appendix was provided to the delinquent.
You may not, unless it is born from the written statement, we will not accept such a statement.
Ashutosh sir, enclosing all the documents
It does not say so. Please show.
on instruction answer.
It says list of documents.
This sort of
Yes, only list, not the documents.
these documents also annexed.
So please either read it or don't read it. Don't just make submission like that.
Oh, rejoinder has been annexed. Rejoinder to the reply has not been annexed.
Yeah. Okay.
Minutes. Little minutes.
Okay. Okay. Thank you. Yes, you know, teacher. That is admitted. WS. In the reply. We are looking forward to this is their reply. We admit was thing. Once you have given you have the but at least go for example, whether Sinha and Manasa. But they are not proof in support any material. So yes or no. But insofar as the other charges, there is no admission. But they say relying on EGS system. So all the charges coming vagueness of the charges, there is one other. It is related and such details specific certificate of these parameters there is not something. Therefore, the charge sheet was not marked. So insofar as what is concerned, we are still yes, that's called. Yes, heard the parties. Parties have been heard.
Will it CIP? Will it any date for the judgment?
Date. Date for CAV.
No. Will it a date for passing the judgment?
That is what you are saying. Call the next one.
Number 8. I got the pardon before proceeding. At page 159 of concept, all documents are defined. Why is it 14 March 2000 that and we the defense bill,
Page.
page 159. Page 159, last 5 lines. Inside file another representation 6 February 2016, wherein they express their that
Copy of the brief. That is PO's brief.
that contains the records.
That is not it. Yes, call the case.
Dreadful.
Report. তুই বলবে বেশি এসে গুড
Wait.
I'm appearing for respondent number 126.
What is the issue? Oh, yes.
jurisdiction issue.
Yes, yes. Tell us jurisdiction issue.
Page number 63 of the petition. Of the application. Particulars of the order against which the application is made. Non-consideration of the representation dated 13/9/2021 and reminders dated 29/2021 submitted by the concerned union before the Director General of Ordnance Factories, some chairman.
Mr. Counsel, you understand the court's query? Then why are you reading all this unnecessarily, wasting time again and again? We have put a specific query. We allowed you time to come prepared. Unnecessarily, you are making irrelevant submissions.
Section 6 of the
You have to deal with the jurisdiction issue. We have told you. For that purpose, we allowed you to prepare yourself. Now, unnecessary, irrelevant submission, why are you making?
Lordship, can I once more get the question? I'm coming back to your Lordship.
No, enough is enough.
Your Lordship, just repeat the question.
Sorry, what is this?
I'll satisfy your Lordship today only.
You will not. We have given you time, still you have not done anything. You are interested in repeating the same thing every day.
Can I place a judgment?
Yes, on the issue of jurisdiction, whatever you want to give, you give. Unless you cross the jurisdiction issue, where is the issue question of going into the merits of the matter?
Citation, sir, WPC.
দিলে না এমনি কোনো সাইটেশন নেই অনলাইন বা কিছু নেই
WPC
আনরিপোর্টেড আছে
Sir, can you understand anything, or you are purposely not trying to? We asked you you have seen the rule. There are only two circumstances in which you can approach a tribunal in a particular geographic location, territorial location. Where is the fact? First, you are giving a judgment.
Section 6(1) subsection 2, my lords.
Yes.
Cause of action wholly.
So we asked you which part of the cause of action arose. We asked you that question.
Lordship,
Where is from your OA, show us which part of the cause of action arose within the territorial jurisdiction of Calcutta bench of the tribunal. You are showing us judgment. From judgment, we'll find the facts.
Over here, my lords, we, the union at Kanpur, had made the representation to Director General of Ordnance Factories located in Kolkata, my lords.
Yes.
Because that being the head office of
Yes.
organization, we
Yes.
made the representation over there.
So making of a representation will confer the jurisdiction.
In part, that can create a jurisdiction.
So show us a judgment.
The judgment I've handed over, paragraph number.
Yes.
Number 16, my lords.
Unreported. Justice Dipankar Datta Division Bench, many judgments. বড় করে বার করে যাই সব বলে দিলাম ওই ডিসিটা বার করে উৎপল বাসু
Relying upon paragraph 15, 17, 19, 20, and 22, my lords.
This is exercise of power under section 25. How this will apply here? Section 25 gives the chairman the power to transfer any case to any bench. Under that power, he has brought the matter before the principal bench. How this will apply? In your case, it has been directed by the chairman. Then why are you relying on this judgment?
Once take you to paragraph number 18, my lords.
Sir, the findings are based on certain facts. These are basic principles of relying on a judgment. A judgment is what the facts are decided, not it will not apply to any other facts. Just because in the ultimate paragraph it says cause of action as a reason, therefore it will apply to you. This is exercise of jurisdiction under section 25 by the chairman. An objection was taken regarding maintainability before the bench, where it had been filed in Gwalior perhaps, or Patna, either of the two places. Then they filed a PT. The chairman exercised jurisdiction. He said, I will take it up in Delhi. So where is the exercise of jurisdiction by the chairman under section 25? Unnecessarily. Paragraph 18 has to be read in the context of the facts which are there in the case. It can't apply to every case. Where is the averment in your OA regarding cause of action? We are asking you, just show us.
'75 and 70.
Yes.
That's 4.13, my lords.
Yes.
And on behalf of its members, made a representation on 13/9/2021 and reminders dated 22/9/2021 before the Director General of Ordnance Factories cum Chairman, Ordnance Factory Board for inclusion of HRA, TA, SF and SFA for purpose of calculating OT allowances under the Factories Act 1948. In view of the identical release granted by CAT Principal Bench, CAT Hyderabad Bench, and in accordance with the orders passed by the Honorable High Court of Judicature in Madras, in writ petition numbers such and such and connected MPs dated 30/11/2011 and in terms of the order dated such and such passed by the Honorable Tribunal in OA number 705/2020, since the Ordnance Factory Board implemented the order dated such and such passed by the Honorable Tribunal in OA 705/2020 and requested the authority concerned to give the same benefits to the members of its union and other employees.
Which authority?
Which is the Ordnance Factory Board, my lords.
Which is respond number?
Respondent number 4 and 5, my lords. In my original application.
Take.
3 and 4, my lords. The Director General of Ordnance Factories and the Chairman, Ordnance Factory Board. Respondent number 3
So
and
therefore, making of a representation is part of the cause of action.
cause of action, my lords, I can see from this chapter, paragraph number 10, my lords, of this judgment. The AT Act does not define cause of action.
Correct, it does not.
Now, my lords, the cause of action, the peripheries of the expression cause of action, however, stands demarcated in several decisions of the Supreme Court. Para 17 of the report in Kunjan Nair, Shivaraman Nair versus Narayanan Nair 2004 3 SCC 277 approves the following definition contained in Halsbury Law of England. Cause of action has been defined as meaning simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person.
See, cause of action is the bundle of facts based on which you seek to enforce a right. That right does not emanate from filing of a representation. The right precedes filing of a representation. It is only when you have a right based on a cause of action that you will make a representation or an application before a tribunal. Therefore, representation is not part of the cause of action. There are judgments to this effect. The law is very well settled. Then you can make an application anywhere and go and file a case there. That's not the circumstance. Section 20 CPC 226 has been interpreted by the apex court in the same circumstance, where making of an application was claimed to be part of the cause of action. It has been rejected. It cannot form part of the cause of action, because that is not the bundle of fact which you are required to prove. You are not required to prove that I made an application, therefore I should get it. The facts preceding making of a representation are the bundle of facts based on which you claim the relief. It can't be looked at that way. What you're reading is undeniable. What is cause of action? This is correct. But whether making of a representation will form part of the cause of action so as to confer jurisdiction on any authority in any territory, then you may make a representation to someone in Tamil Nadu and go and file a case there that I made a representation before this authority. That's not the way it is looked at.
My lords, I was putting a question upon myself, being at a very nascent stage of my practice, my lords. I am employed in Kanpur or Pune, my lords.
Yes.
Now, my lords, I make a representation to the general manager of my factory, who is my boss, immediate boss, my lords.
Sir, we understand and we appreciate that you are new in the profession, but when we are saying something, you should try to understand that. The issue is settled. I cannot give you the judgment today, but I can give you tomorrow. It is a settled issue. Making of a representation will not, or even communication of rejection will not confer jurisdiction. It is the bundle of facts based on which the right is founded. Your right is not founded on the representation. That's not an issue in dispute. That's not something which has to be decided. What has to be decided is the facts which you brought in the representation. Otherwise, it would lead to a very unique situation that anyone can choose any forum in any territory by making a representation. Union of India is throughout the country. Then you can go anywhere you want. That's why the tribunal says either where you are posted or where part of the cause of action arises, part of the cause of action taken from the same expression, section 20 CPC and 226 Constitution of India. Both these provisions contain the same concept of the territorial jurisdiction. So this making of representation will not help you.
Or once, my lords, if I could take you to page 126 of the petition.
Yes.
But there, my lord, my presentation, which I would like to read before you, for once.
That we are not disputing that you have made a representation.
Well,
You may have, huh?
Facts of the representation, my lords.
Why? Which part of the cause of action arose within that jurisdiction? Representation is immaterial.
Matter completely relates to, my lord, grant of HRA, TA and small family allowances, which should be a part of OTA and OTB, my lords.
Yes.
The employers were entitled throughout. Suddenly, my lord, in 2009, the Union of India comes up with a notification saying these three.
We are not hearing you on merits unless we are satisfied with the jurisdiction aspect.
My lord,
We shall not, and we are not satisfied yet. I am being very clear. You should have come with a judgment on the cause of action issue. We are not asking you to define cause of action. We are asking you whether making of a representation will confer jurisdiction in that territory. That is all. Cannot be. I have dealt with that. All right, we'll come with the judgment tomorrow. You look for some precedent on this aspect, not today. As paid.
Keeps the matter on Monday.
All right, as paid list on. perhaps if I remember correctly, on the same issue, where the claim was made that representation was filed and a rejection was communicated. Both these facts have not been accepted by the court. This does not constitute the bundle of facts based on which the right is to be agitated.
নবল কিশোর আছে, ওএনজিসি উৎপল বাসু, নবল কিশোর,
Correct, Naval Kishore.
নবল কিশোর, উৎপল বাসু,
See, I told
ওএনজিসি.
you, I was just telling him Naval Kishore, but I couldn't remember.
Someone prepared with on Monday and placed the charge.
You go through it. You go through it, then you take it from him. I told you Naval. I couldn't remember the citation name. I also remembered.
This is amicus like that. Not I am taking, although I am other side, but
No, it is good. He is young. He should go through it. Maybe he can. We don't know. He can distinguish or not. You go through it.
I was trying to guide him to go through this.
I told my brother Naval Kishore, but I couldn't remember the citation. Yes.
My lord, part heard, my lord.
Why part hurt, sir?
Because your lordship, please to hear this matter.
We'll hear it. Monday is not so far away. Don't worry.
Some line match.
After for further submissions.
He has signed out the judgment, but he's 2 months away at practice already. He's become possibly nervous. He saw see the Lord judgment.
Yeah. Naval Kishore citation is AIR 2014 SP 3607.
তেরোটা টেকে নাও না। এই তেরোটা
Origin side, listed matter under heading 4 orders, serial number 1.
And for the state respondents.
Yes, we find no information.
Absent from orders, serial number 2, Agarwala and others.
I am for the appellant.
I appear for respondent number 4 in this matter. Respondent number 4.
Yeah. What remains when he is already no longer an interim trustee? Then what remains?
My lord, what had happened? Your Lordship, kindly bear with me for 5 minutes. Initially, my lord, 3 trustees, my lord, claiming to be the trustees of Rai Bahadur Surajmal, they made an application under Section 7 before this honorable court, my lord, for administration of the trust, my lord, basically for bank account.
I ask you, when the cause of action does not survive, why are you making submission?
No, he has been removed not in my appeal, my lord.
By whatever means, if the cause of action is gone, then what do you want to submit? How are we concerned with what preceded the matter and what is going to happen subsequently?
What had happened, my lord? He was a trustee.
How does that make a difference? Your prayer is become infructuous. So why the appeal has to be heard out? That we are asking you.
Right.
An infructuous appeal has to be heard.
No.
Then
there are 2 aspects, my lord. Removal, of course, my lord, as your Lordship has observed, my lord,
yes,
that it is infructuous, my lord.
Then,
but my lord, what has happened, my lord, during the time, my lord, there has been defalcation of the fund.
So that is not the issue here. That's not the issue here. Yes, take down. If that is an issue, then there may be. Whereas on what day he has been removed? Just tell us. Nothing removed.
He has been removed, my lord. His main proceeding, my lord,
Yes.
which was ACR, my lord, this has been dismissed, my lord. A review petition was filed, my lord.
When has he been removed? Just tell us the date.
He has been removed by virtue of dismissal of the proceeding, my lord.
Yes.
Your Lordship, I'll hand up the last order, my lord.
All other issues, we are not going to say anything. You may take appropriate remedy, whatever is required.
There was an application for recalling of the order, and Lord Justice Mujumdar was pleased to dismiss that application also by the order of 20th December 2024. And he was removed.
APO 193 arises out of which order? This shows the order.
30th of, if your Lordship looks at the order, volume 3.
Volume 3.
Volume 3, my lord. And my lord, page. It's part of memorandum of appeal, my lord. Page
241.
241, volume 3, my lord.
It's 30th April 2018.
This order was passed, my lord, in their application, which was under the Trust Act, and also my GA, my lord, which is GA2. If your lordship looks at 241, my lord, GA2 in my suit, my lord. Both were taken up together, my lord, and there was a combined order, my lord.
Well, to my submission, this appeal has now become infructuous by the passage of time. It was in Millet a good appeal when it was filed, but now it has now become infructuous.
Yes, sir.
He has been removed, my lord.
That is an admitted position. We'll leave all issues, other issues open.
At the admission of the appeal, my lord, the Honorable Appeal Court was pleased to appoint 2 advocates, my lord, of this Honorable Court, who are now running the trust, my lord, as supervisory trustee, my lord. They have been directed to run the trust, my lord. There is nobody from the party, neither from the contesting parties here who are running the suit, my lord. My prayer was that either somebody may be appointed or the interim trustee may continue, the supervisory trustee may continue. If your lordship looks at
Who has interfered with the supervisory trustee?
the appeal court was pleased to remove the earlier trustees and appointed 2 advocates, my lord, and they are running the trust, my lord. Presently,
They are running it.
they are running.
Then what direction is required?
They will continue to run, my lord.
Who is stopping them?
No, because
there is no occasion to pass such an order.
This order was passed in appeal, my lord.
The admitted position is that the interim trustee is not in existence.
He is no longer there.
He is no longer there. Therefore, appeal has become infructuous. That is all we will say. Whatever else you want to do.
The trustees were the supervisory trustees were appointed in my appeal, my lord. So this in our appeal, my lord.
That there is nothing to do with the supervisory trustee in this appeal.
The trust will remain fungus officio. They will know.
How? You are saying they are all supervisory are already functioning.
They are appointed in the appeal only. In
this appeal.
In this appeal.
Oh.
That is why. Lordship kindly looks at the order.
By which order?
That is why.
Supervisory trustee has been appointed.
23rd should be 20th. My lord, what had happened? My lord, there were 2 sets of appeal. One appeal from the trust, my lord, and one appeal from my application, my lord. And if you lordship, all the applications were together taken up. But if I may read out the order, my lord, that will clear the.
Yes.
Pursuant to an order dated February 10, 2023, ACR 1 filed by the trustees of the trust was dismissed, my lord. As I was submitting, my lord, this was dismissed. And all interim orders passed and vacated. It has been specifically recorded in the said order that petitioner number 1 and 2 in ACR have expired. Since no wakalatnama has been filed on behalf of petitioner number 3, despite several opportunities, it was held that there was none to represent the petitioner, and as such, the petitioner was not interested in proceeding with the said matter. Pursuant to an order dated April 2015, passed in GA number in ACR, my lord, again the same proceeding. The petitioner number 3 therein was appointed as one of the interim trustees, as my learned friend was claiming, my lord, in place and state of Rajendra Kumar Banka. The said petitioner number 3 was the sole signatory in the 2 bank accounts maintained by UCO Bank on behalf of the trust. By an order dated January 5, 2022, passed by the coordinate bench, 2 supervisory trustees were appointed in place and state of previous supervisory trustee in ACR and also in my suit, my lord, because both were taken up together, my lord. Mr. Dasgupta, learned counsel appearing on behalf of petition number 3 in ACR 1 submits that since the 2 supervisory trustees have been appointed in place and state of erstwhile supervisory trustee appointed in ACR with the vacation of interim order on February 20, the supervisory trustee have also been discharged. This was their condition, that they have been discharged. Therefore, the only trustee to deal with the trust fund is his client, the one who has been discharged, my lord. This was his contention. Mr. Sen Learned Counsel, appearing on behalf of plaintiff, my lord, my client, my lord, in CS number 42 and appeal number section, he submits that the 2 supervisory trustees have been appointed in APO 160 since all the matters were taken up together and considered by the coordinator, Mr. Mitra, Learned Counsel, and Mr. Banerjee, Learned Counsel. A report has been filed by the supervisory trustee in court today. Such report is detained with the record. Mr. Samrat Sen, one of the learned supervisory trustee, submits that by written communication dated, I'm sorry, there was a previous order by which they were appointed, and this was the subsequent order which was passed, my lord. In the light of the discussions made in and the materials placed before this court makes it clear that supervisory trustees appointed by the order dated January 5 were appointed not only in ACR, because this was a dispute arose before the court, whether they have been discharged. Only in ACR, but not in CSCS, since the proceedings led to the same trust property and are to continue to discharge their duties until the disposal of the suit and until further orders of this court. So now, Miller, they are continuing to act. If your Lordship passes an order, Miller, today, without touching this aspect of the matter, Miller, perhaps may continue with that. There are various properties, trust properties in UP, in Bihar, in Calcutta, in Rajasthan. They can continue subject to the outcome of the suit also, my lord, if your lordship so desires, my lord. My suit is pending, my lord. Written statement have been filed by my learned friend, my lord, in the suit. All the defendants have been served, my lord.
You are representing all the respondents.
Either one only.
Five.
Five.
They have filed written statement.
How many respondents are there?
Five.
Five, my lord.
My lord, what my learned friend my lord is submitting is possibly factually not correct. My lord will kindly take, my lord, the trouble to have a look at the order which my learned friend has placed. My lord, my learned friend's contention is that, my lord, the learned supervisory trustees were appointed in one matter, not in the other matter. That's what, my lord, his contention is. Kindly take, my lord, page 4 of the order my learned friend has, my lord, placed just now. My lord, this is an order passed on.
No, he has just said that they were appointed not only in both.
That's what I have submitted.
And my lord, this is the order, my lord, appointing.
Submitted, my lord, both.
My lord, the
They were appointed
supervisory
both.
trustees.
That is what I have submitted, my lord.
It's a copy din na. Give me one more copy.
No, but he has placed this. He is not saying he has been appointed in
Yes,
only one.
So, my lord, today, my lord, the supervisory trustees, my lord, are there. Interim trustees is gone. My lord, this appeal is absolutely, my lord, infructuous today.
No, but he is saying what will happen to the supervisory trustees.
Well, they are continuing.
They are continuing because they have been appointed
There is
in
one
those
matter
two cases.
pending. Yes. His ACR is dismissed. CS
Not,
is.
it is not my ACR. Mine is suit. Mine is suit.
CS is there. ACR is gone. So, my lord, the supervisory trustees were appointed both in ACR and in
So
CS.
they will now continue by virtue of
CS.
orders passed in CS 43 of
Correct.
2016.
Correct.
That is all that has to
That
be
will also
recorded.
be clarified.
That's clarified.
They will continue by virtue of this. Yes. Take it up. Who are you representing?
Lord, I was appearing virtually have come down immediately physically.
Yes, so we are passing that only.
Lord, the issue is here. Lord, the issue starts from 2000.
We are not concerned. Yes.
Now, Lord, in 2000, there were three warring groups. Now,
We are not concerned with the matter as a whole. We don't want to go into all this. You have made a submission online that it has become infructuous.
No, Milad, the issue, Milad, if it would have been dismissed, Milad, as infructuous, I would have.
It is being dismissed.
But Milad, clarification which is now being
no
sought.
clarification. We are just going to record his submission that the supervisory trustee is functioning under orders passed in
Milad,
CS.
that is I am opposing. Because why? Milad, if simply Milad dismissed as infructuous, no issue.
Yes.
Milad, I have submitted that.
That is the order passed in CS 43 of 2016.
Yes, Milad, our contention was that.
Milad, where is the order passed in CS 43 of 2016?
Milad, in this appeal. Milad, from this appeal, we have went to Milad Honorable Apex Court.
That is not the point. The point is whether CS 43 of 2016 has at any point of time been interfered with.
CS 43 2016 has never been proceeded with. Milad is lying like that. Now, Milad, our contention.
We are not asking you whether it is lying or not. A supervisory trustee has been appointed in CS 43 of 2016.
No. Milad, my submission was all along before this honorable court. For that, Milad, we have to also need to go to the apex court. Milad, the supervisory trustee was only appointed in ACR, my ACR, which Milad, both Milad, my learned senior friends have been contending that dismissed. Correctly, it has been now dismissed. So Milad, as it has been dismissed, Milad, the interim management cannot continue. That was my contention. Milad, in this appeal, Milad, an order was passed in February 2024. If I'm not wrong, on 20th February 2024, where Milad, this division, Milad, the earlier bench has Milad said that no, we are of the view that we have appointed both the supervisory trustees in CS 43 as well as in ACR. Now, Milad, from that order.
That is 23rd February
Yes.
23.
Absolutely.
Yes.
Milad, from that order, we have went up to Milad, the Honorable Apex Court.
Yes.
The SLP was admitted. And Milad, it was remanded by giving us liberty to raise all contentions before this Honorable Court. From that order, February 23. Now, Milad, my contention is that the supervisory trustee, Milad, they are being newly being replaced. They are not appointed. Milad, appointment is of 2000. There has been several changes in the personnel of supervisory trustee because of old age, death, getting changed. Milad, lastly, Milad, it was Mr. Deepak Basu. Milad, who is now ailman, he is ailing. Milad, then Milad, it was a senior advocate, member of the bar, he has left. Milad, then Milad, the learned two advocates, one senior advocate, one advocate has been appointed. Now, Milad, our contention was that if the appointment was in ACR, and today if the ACR has been dismissed, and Milad, with a rider.
The submission cannot be if it is in this way.
No, it has been dismissed on 10th.
It cannot be if it is like this, then this will happen. And if not, it will happen like this.
I doubt. Milad, it has been dismissed on 10th of February 2024.
Yes.
By the learned single judge. Milad, we preferred a recalling application that has been dismissed in December 2024. That ACR still now stand dismissed. Milad, as on date, there is no ACR. The appointment was in ACR way back from 2000. Now the suit is only of 2016. 2016. Milad, the appointment, if the ACR goes, Milad, the appointment cannot remain because it has been dismissed with a rider that all interim order stands vacated. That's my contention before your lordship. That's my contention because Milad, Supreme Court given me liberty to place all the facts before your lordship. Main process, mother proceeding has gone. That even they can't.
May I try to cut the matter short?
That is not required to be gone in.
Not at all required to be gone into this appeal, but what my learned friend Milord is submitting, Milord, that is not Milord in consonance with Milord what the order says.
We have preferred the appeal. The Supreme Court has given us liberty to place all points before this court. Now this the appeal my lord is taking up.
May I make my submissions, Milord? May I have my lord's Milord?
Place all these matters before this court in these proceedings.
This appeals.
Now, Milord, this is the order. My lords have seen, Milord, the order passed on, Milord.
Which one? 23-2?
No, 5th of January, Milord, appointing the supervisory trustees. Milord, my learned friend is suggesting
to.
Correct.
And from the
No,
may I make my submissions?
Yes.
Milord, kindly see, Milord, two matters were taken up together on 5th of January. Milord, one is APO 160, which is arising from CS. The next one is, Milord, from ACR.
We are taking up APO 193.
correct.
APO 193, what is the issue?
Whether or not, my lord, he is there, Mr. Banka is there, my lord, that has become infructuous.
Only insofar as APO is concerned. We are not concerned with anything else.
Other two appeals have been dismissed.
Then, my lord, need not even, my lord, make any observation, my lord. in
Yes.
this appeal.
Maybe. Not required.
This appeal is limited.
He is the appellant. According to him, his claim is infructuous. What do you have to say? Yes, it has.
My lord, kindly.
Not
That's
required. Not required. Only insofar as the interim trustee is concerned.
He is gone.
Yes. Take down. Take down.
The interim trustees have been appointed by the appeal court.
Hmm?
They are continuing by virtue of the appeal court's order.
That we don't know. Only interim trustees issue is over. We don't know. We are not going.
That's not the subject matter of the appeal.
Yes, the part
not
there
the
is
subject.
no dispute.
Grateful to your lordship.
They have given their appearance. All have given their appearance.
On the joint request,
Lord, if the matter can be taken up on 8th or 9th of July, my lord. In the meantime, my lord,
matter.
Lord, the 2 p.m.
2 p.m.
fixed matter, my lord. Item number 6. তোমরা এই এগুলো-
And then the last matter that we took up before lunch. It's going to put it in the file. The yes, we call the list.
Item number 6.
Yes.
But if the matter can be taken up on the 8th or 9th of July, my lord.
As prayed.
Item number 11.
We filed the paper book, lordship. They have supplementary papers during this period, lordship. One paper which was not there in our records, except that we have prepared the supplementary paper book. May I file the supplementary paper book? We filed.
6, why we have come to 11? What is happening outside? Somebody is fighting.
आरंभ করছো 198 পেপার 198 তো তোমার কোন দিকে ধরবে ট্রাইব্যুনাল ইনক্লুড হবে
Yes.
I'm led by Mr. Jyoti Prolor.
Private respondent is here.
The private respondent is here.
Take your lordship, Lord, first brief facts. Lord, West Bengal Civil Services Executive Examination 2011 is the issue. There was a delay in holding the examination. This was held around 2013-14.
Yes.
Now, Lord, the respondent number 1 him, Lord, participated for Group A and Group B category. Group A is excise service.
Yes.
And Group B is police service.
So the recruitment process provided exercise of an option for which post you are applying at the initial stage.
Yes, it does. It does. One can opt for both. Now, my lord, there is a common entrance exam. This common entrance exam, in which he written test, he got 512 marks.
Yes.
Then, Lord, there was a separate interview. Now, Group A interview was held on 9th of February 2013. 19th of February, sorry.
19th February?
2013.
Yes.
Now, Lord, in this, he obtained 158 marks out of 200.
Yes.
He was ranked 28.
Yes.
Now, Lord, so far as Group B is concerned, this interview was held on 2nd May 2013. Group B is police service. Lord, he obtained 80 marks of 200, out of 200.
Yes.
In Group B, his rank was 39. There were 16 vacancies in Group B. So, Lord, he did not succeed in coming under the zone of consideration.
By far, yes.
By reason of his marks. The last recommended candidate in Group B had got 625 marks. Whereas his marks was 592. Taking his interview marks and written examination marks, 590. But Lord, he got employment in Group A. He was selected. There were more vacancies in Group A. He got selected and he was appointed. Lord, please come to page 61. This is appointment letter. This Lord, 6th of January 2014.
61.
Yes, Lord. Are your Lordship looking at the paper book? Because, Lord, last time when I was moving the stay petition, there was some problem in the pagination.
Yes.
Has your Lordship got that?
6/1/2014.
Yes, 6 Jan. This is his appointment. Says the governor is pleased to appoint Sri Shondip Kumar Rai, so and so, on the basis of the result of West Bengal Civil Service Executive Examination 2011, temporarily as a Deputy Excise Collector in the West Bengal Excise Service in the pay band, etc. Lord, he has been confirmed. Subsequently, he is working in this department.
Yes.
Now, Lord, he was obviously dissatisfied, and Lord, he raised certain questions under the Right to Information Act.
Yes.
Now, Lord, there are various letters. I would not trouble your Lordship with that. Straight away, my Lord, come to page 63. This was one of the replies that PSC gave pursuant to his application. his basic focus was that the interview board consisted of 4 members and in group A, and for group B 3 members. So the focus of his query was that whether how many members were there in the interview board. If your lordships will kindly come to the third reply, reply to the third question replied regarding fourth query. Has your lordship found that?
Yes.
The interview board of West Bengal Civil Service Executive etc. examination 2011 for Group A, Group B services were composed of 4 and 3 members respectively, including the presiding member. That is the member of the commission in each case. It is to be mentioned that apart from 3 members, that is advisors, and 1 presiding member for Group A service, the Honorable Chairman also selected member of this commission for the same board to act as a member of this commission. And then more clarity is there in answer to question number 6. The interview board of West Bengal Civil Service Executive exams in 2011 for Group B service were conducted by 3 members, including the presiding member, that is member of the commission. So this information was with him on 28th May 2018.
So for group A, 4 member.
Group A, 4 member.
And for group B, 3 member.
3 members. He was selected for Group A. His grievances with regard to Group B.
He's alleging that there is no level playing field.
He is saying his main contention is that it should have been consisted of 5 members.
Both the boards.
Both the boards. He is not challenging his selection in Group A, but he is saying for Group B, the 2 members who were short, give me proportionate marks for those 2 members. He is not.
How 2 members were short? Because for Group A, there were 4 members.
For Group, we are only concerned with Group B, because he is now asking the PSC to give him proportionate marks for selection in Group B post. He wants to join Group B post.
That's all right. But then Group B, as per this reply to RTI query, is short by only 1 member.
1 member. According to this RTI, and the tribunal initially proceeds on the basis 1 short, but in the final order, he says that
they are 2 short.
2 short and give the marks.
Maybe it's because it says that the chairman also selected a member of this commission for the same board.
Lord, I will take your lordship to the guidelines, Lord, for the purpose of appointment of the committee for the interview. I'll take your lordship to that. But Lord, I'm trying to summarize the challenges which is being raised, because these queries which were raised under the Right to Information Act, the main focus was that to find out how many members were there for selection as on the date of interview, because he had himself appeared. So he knew that there were 3 members. But even then, he made applications, Right to Information Act, for this disclosure. But all this time, he was working in the Group A. He is still working. He is still working, Lord, in the Group A. Now, Lord, kindly come to page 65. This is how, Lord, the problem started. Lord, come to, this is dated 11th June 2018.
Yes.
Lord, the reply by PSC, earlier reply was 25th May. On 11th June, kindly look at question number 2 and 3 only. Kindly furnish the final score sheet of the selected candidates in WBCS Group B Service 2011, encompassing their respective mark sheet for the mains and interview. Also furnish the name and final marks for the last selected general candidate and reserve candidate categorically for the said Group B service. Now, my lord, this was answered. Your lordships may kindly see the reply, which is, lord, at page 66. Or rather, my lord, come to page 67. Kindly see the second query, reply to second query. The photocopy of final mark sheet is attached herewith. Has your lordship seen that?
Yes.
Page 67, Lord, the question is set out. Kindly furnish the final score sheet of the selected candidates who were finally selected with service 2011 encompassing their respective mark sheet for the mains and interview. It says photocopy of the final mark sheet is attached. Then fourth query, kindly furnish the copies of the preference list invariably submitted by each of the group B selected candidate for WBCS 2011. It says reply, for the proper preservation of examination related documents, pest control work is undertaken on regular basis in the office of the commission. But owing to situations arising out of pandemic, which is still prevailing, the said pest control work could not be undertaken. As a result, several documents, including the information sought for by the candidates, were irretrievably damaged. Further, it is worth mentioning that as per FC meeting dated such and such, answer scripts are to be made available for supply of copies to or inspection by candidates applying under RTI Act for a period of 6 months from the last date of dispatch of the list of recommended candidates of all categories of services, etc. And accordingly, choice sheets and other related papers are not maintainable beyond the time stipulated by FC in respect of the answer sheet. Now, Lord, so he got mark sheet, but so far as the fourth query is concerned, preference list submitted by each of the Group B selected candidates, note that was not furnished.
What was not furnished?
Note, kindly come back to page 67.
67, yes.
Note the fourth query, kindly furnish the copies of the preference list invariably submitted by each of the Group B selected candidates for WBCS 2011. Lord, what
so it was only for a time, particular time it was preserved, thereafter it is not.
It was not, it was not available. And Lord, these are, Lord, the candidates, when they apply, they give their preference. So if that preference is given, normally he is considered in that category first, and then if he doesn't get it, then Lord, the other categories are offered.
Yes.
So, Lord, he challenges this reply and comes to High Court in a writ petition. So, Lord, if your lordship kindly comes to page 79, there are 3 orders, Lord, which was passed in this writ petition. First order is dated 8 June 2022. Has your lordship got that? Lord, please come to the last paragraph of this order, where, Lord, it says that the petitioner is aggrieved by communication dated 23rd February 2022. This is what I showed to your lordship, Lord. Page 67.
Yes.
Then, Lord, it says prayer for disclosure of the preference list was rejected on untenable grounds. This is what he says. While the final mark sheet was furnished to the petitioner, it would appear from the decision of the Information Commission dated such and such that the State Public Information Officer was directed to provide the records. Since the respondents are not represented, counsel appearing for the petition is requested to communicate the direction as given below. The respondents are directed to file report, bringing on record the reasons for non-disclosure of the preference list of the petitioners, as well as the final score sheet. Final score sheet was given. The report shall be filed within a period of 3 weeks. Now, my lord, the next order, the report was given. Pursuant to this order, report was filed.
Yes.
Page 81, if your lordships kindly come to, your lordships will find that the report was filed, it was taken on record. And finally, the writ petition was disposed of by an order of 18 July 2022. My lord will find that at page 82. Look, about 4 lines from the top, your lordships will find the sentence starting with the word, the SPIO.
Yes.
But ultimately, the High Court held that, Lord, considering the report, that, Lord, the petitioner was outside the zone of consideration. And, Lord, it was further held that the merit list gives a cause of action. If he wants to challenge the merit list, he is free to do it. But, Lord, the High Court also says that upon perusal of the report, it appears that the PSC has enclosed a merit list for Group P services, etc., which contains at least 2 names having better ranking compared to the petition. And then this court is of the view that the merit list indicates the position of the candidates and further shows that the petitioner was outside the zone of consideration for Group B service, which was petitioner's choice. Notwithstanding the initial excuse given, PSC has now produced all relevant records before the court. Considering the prayer in the writ petition, there is no remaining issue which the court can go into. The merit list gives a fresh cause of action. So and so is accordingly disposed of. So, my lord, an OA is filed. In 2023, this OA was filed, which your lordships will get at page 47. Starts at page 47. Kindly see the prayers, my lord, at page 57. Instead of challenging the merit list, Lord, the challenge was with regard to constitution of the committee for the interview. Page 57 are the prayers. Now, Lord, rest of all the details, if your lordships, Lord, kindly sees, there was a report, Lord, which was directed to be filed also before the tribunal, which starts at page 95.
Yeah.
Lord,
Annexure W.
essential, yes, Lord, this is
Page 95.
annexure W. No, this is wrong. I am wrong. Look, this report was filed in the writ petition, not before the tribunal. In the tribunal, there was a reply filed, page 99. I made a wrong statement. But Lord, instead of taking your lordship through the pleading, I take your lordship through the order. I think, Lord, I'll give your lordship the page. There are 3 orders. First is 29 January 2025. That is, Lord, page 113. Please come to page 116. Kindly come to the middle of that paragraph where it is recorded, in reply to the query, the Commission in its reply dated 25/5/2028 stated the following. The interview board of West Bengal Civil Service Executive etc. Examination 2011 for the Group B service were conducted by 3 members, including the presiding member, that is member of Commission. And Lord, your lordships will find at page 124 the operative part. In the above-mentioned background, I am of the opinion that the applicant has made out a prima facie case for which judicial intervention is emergent, keeping in mind the facts, materials available in the record and the judgments. I am constrained to direct WPSC to apply the proportionate quotient and recommend the case of the applicant in Group B service for the WBSC examination, etc., examination 2011. Within a period of 4 weeks from the date of communication of the order, Mr. G. Banerjee, learned advocate appearing for the state respondent, had mentioned that all vacancies for the said post, etc. examination have been filled up. In such circumstances, the respondent, number 1, the Secretary, Department of Personnel and Administration Reforms, is directed to create a supernumerary post in consultation with the Home and Hill Affairs Department to accommodate the applicant with retrospective effect, giving his seniority vis-a-vis the person who has been selected in 2011 WBCS examination, Group B examination within 3 months from the date of his name being recommended by the WBPSC for the Group B services, and the applicant is otherwise eligible for the post in accordance with law. Your lordships will find that, Lord, this is based on the finding that, Lord, the interview board was short of members. Kindly, Lord, come back to page 118. The rationality, your lordships will find at page 118. After hearing the submissions, that paragraph your lordships will kindly take. Submissions of the learned advocate representing the respective parties, and on perusing the available record, it is an undisputed fact that the applicant got 512 marks in the written examination and got 152 marks in personality test for Group A service. The disputes regarding the quorum for personality test for the Group B service on 2nd May 2013, it was the contention of Mr. Rai, learned senior advocate for the applicant, that in paragraph 6C of the original application, the applicant had clearly and without any ambiguity had stated that there were only 2 members, namely Sri Nurul Haq, the then chairman of the commission, and Sri Tapon Chattopadhyay, instead of the required 4 members to form a proper quorum. Order 8 of the Court of Civil Procedure specifically deals with the written statement of the defendants in the plaint. In reply filed by the Commission, there is no specific denial with regard to the averments made in paragraph 6C in the instant original application. Order 8 Rule 4 deals with evasive denial. This rule clearly states that when the defendant denies the allegation in the plaint, he must not do so evasively but answer in point of substance. Order 8 Rule 5 deals with specific denial. it is well settled principles of law that if the allegations are not specifically denied or controverted, the presumption would be admitted to the allegations made in the plaint or as the case may be. Now, my lord, these observations came, Lord, without Lord taking note of the defense that is noted in paragraph page 116. Your lordships have already, Lord, seen that, Lord, the commission stand has been in reply, has been quoted in page 116. Commission specific stand was there were 3 members.
And he is recorded 2.
2. And Lord, he says that, Lord, there is no denial of these facts.
No, but even if it is 3,
yes,
then still the order of the tribunal is that it is not a level playing field. Therefore, proportionate quotient has to be given.
Correct. Lord,
this will not make much of a difference. The conclusion is still that the 2 boards could not have been at disparity in terms of the number of members.
Correct.
This is what he is trying to.
Correct.
Yes.
But Lord, the issue today is something else. The issue is that, Lord, the tribunal says that this will be accepted as 2-member because there is no denial of the fact. I am saying, Lord, I am joining issue there. I am saying that in coming to this conclusion that order 8 will apply in a situation like this, the tribunal overlooks its own finding, which is recorded in page 116.
Yes, that we have understood. Yes.
So therefore, Lord, applicability of order 8 is
error apparent on the face, you are saying.
Absolutely. And Lord, the question is, it is another question which Lordship poses, that Lord, in the given facts, even if there were 3 members, whether that is sufficient quorum, that I will address. But Lord, the
factual premise is suffering from an error apparent on the
face of the
Yes.
This is one. And the secondly is, Lord, on a legal issue, whether, Lord, the tribunal could have directed creation of a supernumerary post for the
before that proportionate quotient could it have directed?
I'll come to that. Proportionate quotient.
Because the supernumerary post is a consequence of this finding.
Correct. Proportionate quotient, the tribunal says only give it to him.
That is precisely why we are asking whether it could have directed for giving it to him.
Absolutely not. Because
that is the primary question.
Proportionate quotient is to be applied. It should be applied to all the candidates.
The proportionate quotient becomes disproportionate.
Absolutely. I'm obliged to your lordship. Lord, if the proportionate quotient is to be applied, it should be applied
across the board.
Across the board.
So ultimately, result will remain the same.
Absolutely. Absolutely. This is my humble submission. Now, Lord, kindly see the next order, which is dated 28 February 2025, page 148.
Yes. 148.
Lord, 148 is the second order. Lord, I'll tell your lordship what happened. After the matter was disposed of, a miscellaneous application was filed. Lord, your lordships may kindly take the.
So this order was, you did not assail this order?
Yeah, I have. I have. All the 3 orders are assailed.
In these proceedings?
In this proceeding.
A composite writ petition you have filed?
Yes, I have.
Why did you not challenge this order?
But this is
29/1/25?
28 February 25, and the next order is passed on 28 March 25.
No, this is 29/1/25.
That is, Lord, the first order.
Yes.
29 January 25.
Yes.
But immediately thereafter, a miscellaneous application was filed. That is, Lord, at page 126.
Yes.
But this prayer of this application is at page 133. Add Principal Secretary, Home and Hill Affairs, Department, Government of West Bengal as added respondent and to direct said respondent to comply with the order being the appointing authority, Group B. So, my lord, after disposal of the matter, Order 8, Rule 10, application, which didn't come during the course of adjudication.
Yes.
Now, my lord, kindly see the order, how it is disposed of. 149. 148, it starts at page 149. In view of the above facts, let the concluding paragraph of order dated such and such be modified and read as follows. In the ground, I am of the opinion the applicant has made out a prima facie case for which judicial intervention is emergent. Keeping in mind the facts and materials available in the records of the judgment, I am constrained to direct the WPC to apply the proportionate.
Now seniority also.
Now seniority also.
What is the date of this order?
But that the date of the order is 28th of February 2025.
There is a third or
Yes. Now, my lord, there is a third, before the third order, there is another miscellaneous application. Your lordships may kindly come to page 170. The application starts there and the prayers are at page 173.
170.
170 is the miscellaneous application.
One 173.
173 is the prayer. Is requested your kind honorable lordships for making right explanation for awarding proper marks in the instant applicant's favor, notionally under the said manner being the proportionate quotient method of distributing interview marks therein.
What does that mean?
Lord, I really don't know. It says that it has to be with reasons, the marks has to be allotted or whatever it means. Making right explanation for awarding proper marks in instant applicant's favor, notionally under the said manner being the proportionate quotient method of distributing interview marks there.
Oh, so he wants the quantification of the notional marks. So he is telling that tribunal, you give a right direction, explanation as to what is the quantification.
How the quantification would be made. And Lord, the tribunal of course obliges. Kindly, Lord, see 176. That page 176, the order starts. Kindly come to page 177. In the above mentioned background, I am of the opinion applicant has made out a prima facie case for which judicial intervention is emergent. Keeping in mind the facts materials available, I am constrained to direct WPSC to apply the proportionate quotient, which is the in this case means twice the average of the total marks given by two present interviewers to compensate the vacuum of marks created due to the absence of the other two.
Twice the average of total marks given by two present interviewers means the assessment of one person.
No, tribunal proceeds on the basis there were no 3 persons. There are only 2 persons because the first order says 2 persons.
No. But if there are two members, they both give 10 marks each, then 50%, twice of 50% is 10. So therefore, I am saying it means one more person giving the same marks.
Absolutely. Your lordship is right. So, my lord, assumption reaches the sky. This is how, my lord, the order is perceived.
Is twice. To be some of the persons. Right. So he claims that there should be 4 members. Therefore,
and he doesn't accept that there was 3.
Yes, according to him, there were 2.
And though PSC pointed out by name
Yes, that you have shown. That you have shown. At 116, you have shown.
Fine. Now, Lord, kindly have a look at the rules of procedure, which starts at page 185.
At page
185. But please come to page 191. But in fact, it starts from 188. The source of recruitment can be by selection. Your lordships kindly, Lord.
It starts from 188. You said 185.
It starts at page 185. I'm sorry. Please come to page 188.
Yes.
Where it is, there can be recruitment by various methods. This talks about selection.
191.
191 is not the constitution of the committee. It says shall constitute a board or selection committee consisting of one or more members of the commission.
No, which page you want to refer to?
I wanted to refer to
188.
188 first.
Yes.
Lordships will find that this is how the recruitment is to be made by selection.
Yes.
But kindly see 4. This procedure number 5.4.
Constitute an interview board.
Interview board with one or more members of the commission or a nominee of the chairman. Then chairman member will preside in all interview boards whenever he is associated. When 2 or more members are associated, the senior-most member will preside. In other board constituted without a member, the nominee of the chairman shall preside. Then the board will, if necessary, be assisted by one or more specialists or experts of standing not connected with the department directorate concerned chosen by the commission. In the said interview board, the commission may request an officer of the appropriate rank, ordinarily not below the rank of joint secretary or head or additional head of the directorate nominated by government to represent the department directorate for which recruitment is made. Then proceedings of the board shall not be invalidated. Lordships may kindly mark this by reason of absence of any member or expert departmental representative.
But this was not even placed or considered by the tribe.
This was not placed, but Lord, the commission only said that there are 3 members. There were 3 members.
No, that is all right. But when he sought proportionate, what is it?
And Lord, this
Proportionate quotient.
proportionate quotient issue,
Then in that case, you did not tell the tribunal that this rule was there and that there's no question of giving any marks whatsoever. This whether you had raised this issue before the tribunal.
I'll just take 1 minute of your Lordship's time. Reply to the main OA is 104 to 111 and the supplementary is 99 to 103. I'll just have it checked.
Probably not. This is not discussed in the order as we have seen. The order only goes on the RTI, giving the number. It notes your stand as to the number of persons comprising the board. Then according to you, it takes a stand which is contrary to your stand recorded. And
Yes. And Lord, the first issue should have been addressed is the delay. Because in 2018, Lord, this fact was known to them on the basis of RTI reply. The first RTI reply, which Lord gave the details of this number of members, is 25th May 2018. The writ petition was filed in 2023. Because Lord, when the High Court proceedings was taken up, the High Court proceedings, this was not the issue. The members forming the committee, etc. High Court proceedings was absolutely on the question of question number 4. Disclosure, question number 4. Your Lordships may kindly have a look at the High Court proceedings. First order is 8th of June. Final order is 18th of July, which is page 82. And question number 4, your Lordships will find it at page 67. The preference list of all candidates.
no, the information regarding the number of members
Yes.
is in response to RTI query dated 25/5/2018.
Yes.
And what is the date of the response?
The date of the response is.
Oh, it is in this only, 25/5/18.
25/5/18.
Page 63.
Page 63. And Lord, when he comes to the High Court, Lord, he doesn't raise this issue.
Yes.
He goes on this preference list, which is question number 4. And Lord, the High Court calls for the records, ultimately disposes of the writ petition. So Lord, the selection issue was never an issue before the High Court. Selection committee. Read exact date of filing, page 59.
OA when he has filed?
I'll just give your lordship the date. It is there. Page 59.
23.
Just Lord, page 59. It was filed on 13th of April 2023.
3.
Yes. Page 59.
261 of 23.
261 of 23. Their lordship will find the date of verification, page 59.
It is 13th April 2020.
Yes, 5 years after.
13th April 2020.
Yes, 13/4/23, 5 years after.
Lord, I raise 2 points before your lordship. First is the delay. That, Lord, unexplained delay. In the OA, there is no explanation for this delay. This is one. The second is, Lord, I take this point that, Lord, the point which could have been urged in the writ petition but was not urged. A constructive res judicata.
What was the WP number? WPST?
WPA number 8047 of 2022.
24.
22.
Yes.
Lord, your lordship had, Lord, put a question that what was the defense taken before the tribunal, whether this point was taken and urged, whether this point was urged. Lord, I don't see from the order of the tribunal that this point was taken, but Lord, in the defense, this point was raised.
It was in your WS,
Yes.
in your reply, whatever you.
In our reply. If your lordship kindly comes to page 108.
Yes. In fact, you have quoted that provision.
Yes.
In whatever jurisdiction.
Lord, just one more document, Lord. I'm sorry.
Yes. One more document.
Lord, please come to page 182. But I must say that this document was not there before the tribunal. This is, Lord, on the constitution of the interview board. But please come to page 182.
Yes.
Kindly see the third paragraph. Board may be constituted for the purpose of holding the personality test, and advisors may also be chosen to assist the commission at the interview board. Then a list of advisors is placed below at flag A for kind perusal and consideration. Please turn the page. It says if approved, in that case, 115 candidates, general such and such, may be called in for PT for Group B service, West Bengal Police Service, against 33 vacancies. General 16, B, so and so, so and so. He belongs to the general category. Please turn the page. Honorable Chairman had a discussion with the Secretary and myself. Honorable Chairman will take the interview for the personality test. The personality test of the candidates may be held on 18 so and so, so and so, in 2 sessions each day commencing from such and such, etc. A list as placed below flag FX may be perused from page so and so. Sri R.P. Singh and Sri Tapan Chattopadhyay be selected as advisors. One chairman and these 2 advisors. Please come to page 184. The following advisors, Sri Tapan Chattopadhyay, Sri Rajendra Prasad Singh, attended the personality test, main examination for Group B services in the chamber of Honorable Chairman, Public Service Commission, West Bengal. The personality test of candidates were held on such and such day.
Chairman was the third person.
Chairman was the third.
No, but there is no prescription that a particular number has to be there.
Chair, either the chairman, if your lordship goes back to that
188 you were showing.
Yes, Lord, please kindly have a look at page 188.
With one or more members of the commission. One or more members of the commission or a nominee of the chairman.
Either they have to be a member of the commission or a nominee of the chair.
No, but it does not say that minimum 3, 5, 4, 2. There is no such prescription.
It does not. It does not.
So therefore, what he is aggrieved by is the numbers.
Correct.
He is not on the competence of the members, that whether they are members or whether they are nominees or not.
Absolutely.
He is on the numbers. So numbers, there is no prescription. Therefore, why you are relying on D?
No, I am only saying that, Lord, these are the prescriptions which is there.
Yes.
And Lord, prescription is that there has to be one member of the commission or nominee. So there has to be a member. The chairman himself was representing the commission.
Yes.
So that category got fulfilled because note says chairman member will preside in all interview boards, etc. If there is a chamber or is there the chairman or Lord, a nominee of the chairman, they will preside. And then he says that board will, if necessary, be assisted by one or more specialist or expert of standing, one or more. This is one or more. Not connected with the department directorate concerned chosen by the commission. Though there were 2 experts chosen by the commission.
So if there was absence of any of these, then you may be required to rely upon D.
Correct.
It is not his allegation that there is an absence of a member or there is an absence of a nominee.
He says that
He is only saying the number is insufficient.
Correct. So, Lord, that is the reason why, Lord, the quotient was applied.
Yes, and that has been accepted by the tribunal. He is not on the competence of the members.
No.
Whether they are incompetent, that's not his case.
Not
He says the number is not sufficient and therefore give me a proportionate quotient, which the tribunal has accepted.
So, Lord, merit list, he doesn't challenge. Despite the liberty given by the High Court, merit list is not challenged. The only challenge is with regard to the constitution of the committee. Yes. Lord, in fact, at page 25 of the petition, I have given a calculation that if this quotient is applied, his position doesn't move because it has to be applied down the rank. But if your lordships kindly take paragraph 23. Page 24. Last 3 lines. The details of the marks obtained by the last recommended candidate and the marks of the respondent number 1 after applying the proportionate quotient with effect of the order dated such and such, read with orders dated, the candidates are as follows. Lord, he is Shondeep Rai. So his position remains same.
It has to be that we observed that if the moment a quotient is applied across the board, nothing will change. The ultimate result will remain the same. Unless it is given to him and him only.
Absolutely. Now, Lord, there are, apart from the initial points of delay, Lord, and the res judicata, the issue is, Lord, whether the tribunal could have directed it to allow this proportionate quotient.
It does not say to incorporate this quotient in the result. It says to give him this quotient and appoint him in group B, and thereafter give him the seniority also.
Absolutely. So, Lord, my first attack to that portion of the order is that the tribunal became the appointing authority, which it could not have in the exercise of power of judicial. If the tribunal found that there was a defect in the selection procedure, it could have set aside the selection procedure by directing the petitioner to add those persons who have been the recipient of the benefit of selection under Group B.
But he has not challenged the validity of the selection.
He has not. So, if he has not challenged the validity of the selection, then
That would have been self-destructive.
Self-destructive.
Because he is a beneficiary of that.
Absolutely.
He could not have.
Absolutely. So, Lord, without challenging the procedure, Lord, whether he could have prayed for, without challenging the selection, whether he could have prayed for these reliefs. That's the next contention. And Lord, in judicial review, that's my next contention, that in judicial review, the tribunal has a very, very restricted. It couldn't have given the relief that it has given. 93 to the hour.
Yes.
But I just want to cite one judgment on this point. 1993, Volume 3, SCC 552. Paragraph 17, if your lordships kindly take. The appointment of public prosecutors, Lord, in issue.
Paragraph 20.
17. But it simply says that the court can look into the decision-making process. Your lordships may kindly see para 17. Placitum E, Lord, if your lordships kindly read from, while exercising the power of judicial review, even in respect of appointment of members of the legal profession as district government council, the court can examine whether there was infirmity in the decision-making process. Of course, while doing so, the court cannot substitute its own judgment over the final decision taken in respect of the selection of persons for these posts. It was stated that in case of chief constable, etc., the purpose of judicial review is to ensure that the individual receives fair treatment and not to ensure that the authority, after according fair treatment, reaches on a matter which it is authorized or enjoined by law to decide for itself a conclusion which is correct in the eyes of the court. And Lord, then paragraph 18, the court says that he has followed the procedure prescribed. Lord, infirmity in the decision-making process can happen when, Lord, the procedure prescribed has not been followed. That is the reason, Lord, why I showed your lordship the prescribed procedure, where, Lord, there can't be any issue at all. There were 3 members. Those 3 members' competence has not been challenged. It's not a case that I selected somebody who was not competent to select so many people. In fact, so many people were selected in that selection procedure. and not a single person has come. He has himself been a beneficiary, as rightly pointed out by your lordship. It is not his case that selection in Group A should be set aside. He is only concentrating on Group B because he wants to join Group B from Group A.
The same argument can be raised by one who has been appointed in Group B,
Absolutely.
that you remove a proportionate quotient.
Absolutely. Lord, the next judgment is also on judicial review. This is 2013, volume 5, SCC. 489. Kindly take para 30. There are a lot of discussions. Lord, starts from para 27 onwards, but 26 onwards. But Lord, the summary is in paragraph 30.
So this is relying upon this judgment only.
Relying
Or
upon-
Pal Singh judgment which you have just placed.
Yes, and this followed, Lord, it says that court cannot grant mandamus sought
Yes,
by the
we have seen it.
to issue appointment order.
Yes.
It's exactly what has been done. And Lord,
This is what I said. Yes.
but the other point is with regard to the retrospective seniority, whenever that could have been given by the tribunal. 2021, volume 14.
So there are two aspects. One is direct recruit engineers. Unless a person is born in the cadre, seniority cannot be given.
Absolutely.
The other is in absence of those whose seniority is to be affected.
They have to be added.
They were required to.
These are the two aspects of the matter. These are really the two aspects.
This is glaring from the facts itself.
Glaring, absolutely.
Yes.
Because Lord, he was appointed in Group A. He had nothing to do with Group B. So people who have been appointed in Group B, they are
One will have to make way for him. At least one will have to make way for him.
There is a direction to create a supernumerary post. But that supernumerary post creation is going to affect their seniority.
Seniority ultimately will be affected.
So, my lord, paragraph 10 to 12, if your lordships, this retrospective seniority issue.
Director Course Class 2 Engineering Officers Association, that is the judgment.
Yes.
This is a leading, it has been relied upon in this.
That is the judgment which has been relied upon. I just cite the last one, 2021, volume 14 SCC, page 38. Page 38. Lord, these are my submissions. I say, Lord, the impugned order of all the impugned orders should be set aside. There is no scope for.
Yes, that's all. You have nothing to say.
118, relying on order 8 rule 5. 96 section.
CPC will apply to tribunal.
No apply. That's my submission.
The statute itself says that CPC shall not apply.
Right. That's it.
Then why order 8 rule 5?
How the tribunal could get it? And my lord, so far as
Where is that provision? CPC will not apply. Section?
Section 22.
22, yes. Guided by principles of natural justice.
Natural justice. And for limited purpose.
Yes.
Subsection 3 is for limited purpose.
No, these powers are given to many authorities.
Many authorities.
This power is for summoning and enforcing attendance.
Cooperative Societies Act and other
This power is given to even administrative authorities.
Given by the West Bengal Land Force Act,
Yes.
the revenue officers, and by the collector. And whatever, so far as promotion with retrospective effect. And what about in West Bengal, the West Bengal Public Services conduct 4 types of staff. Group A, administrative service. Group B, police service. Group C, clerical. Group D, clerical cadre others. And Group B service. If somebody is selected in a Group B service, he will be appointed as a Deputy Superintendent of Police on completion of training. 1 year complete training. And training, then he will be posted anywhere as a deputy. Then on completion as DSP. Then his next promotion, additional SP. Then if he is successful, he is nominated in IPS, then he will go to the Superintendent of Police. Now he is holding the post of Group A service. How could be converted into the Group B service, who is a police service? That has not been considered by the tribunal. Group A administrative, just initially after selection, joint BDO or BDO is appointed, then he is appointed as a sub-divisional officer, then he is promoted to the additional district magistrate, then after he gets a nomination, district magistrate. But Group B service only restricted to the police personnel, and police personnel must have a training.
1 year training.
1 year training at Barakpur Police Training College, horse riding, etc., revolver, rifle, arms. If today he is to be given promotion as a police officer,
it is PTC Barakpur.
PTC Barakpur, Police Training College, Barakpur. Now it is named as Vivekananda Police Training College. Initially name was Latbagan, now it is called Vivekananda Police Training College. I do not know how the learned tribunal could pass an order that he should be given by creating a supernumerary post. And I don't find any other positions in the Tribunal Act. The tribunal can make a judicial scrutiny of the order passed by the tribunal. Selection is made by the tribunal. If 3 members were there, then marks should be divided by 3. If 5 members is there, they divided by 5.
A direction is to be issued for creation of a supernumerary post in what circumstances?
Yes.
What circumstances?
Terms of if somebody is eligible,
yes,
but he has not been deprived of promotion, then it will go to the cabinet.
No, the court normally issues this direction under what circumstances?
But a supernumerary post has to be created under, even normally High Court has no normally jurisdiction, but sometimes for the ends of justice, if somebody is deprived of promotion
Correct.
for a particular post and he has been fighting for a white year and no post is available, then create a supernumerary post particularly.
Normally it is done when there is a delay in the court.
Yes.
And the party should not be made to suffer on account of pendency of the matter in court.
Yes.
And the posts have been filled up and it is a glaring circumstance, then the court says, all right.
And mitigating circumstance.
Normally this is the,
although
this is not a limitation, but normally you will go through the judgments, most of them are on this ground only.
Extreme hardship. And Supreme Court sometimes in exercise of power article 142 passed an order.
No, that is a different thing.
But what
That
judgment
we
is,
need.
but the Supreme Court in 67 Supreme Court, that whether power under Article 226 is less than 142. But one of the
See, that is a very dangerous.
now the debate is going on. That's why there is a reference made by the president akin to. And my Justice Ganguly, the Supreme Court said that 142 power cannot be exercised towards the law. If there is a law, you can exercise the power under what?
Recently also there is a. If that is all. Yes, sir.
I hope I cannot finish today, my lord.
We hope you will. You may not, but we hope you will. Yes, we remember you had mentioned. We thought you will mention today, but you did not. So now the hearing has commenced. Everything, leave everything aside. The composition of the interview board, whether the court tribunal had the power to pass a direction for giving a proportionate quotient. The point is, can the tribunal pass an order giving an undue advantage to one person in a recruitment process? That is the only point. What is the order? The tribunal has said that this person who has come before me, he says that the composition of the interview board was not comprising of sufficient number of persons. So I must be given a proportionate quotient to make up that deficiency. The tribunal says you give it to him, you appoint him, and you give him seniority, creating a supernumerary post. And all those others who have been subjected to the same interview board, their result remains the same. No. Any tribunal or court will pass an order only when it finds that the right has been infringed. But the remedy provided by the forum, can it result in such kind of a discriminatory effect? No, facts are not. What fact is in dispute? What fact is in dispute? See, which fact you are disputing which they have said? That is not in dispute. They are also saying you appeared. That's not in dispute.
And all the persons whose name was cited for candidates marks were given in paragraph 23, 24. And so you will not see how the public service commission has made me not even without a mobile to the author or the children by giving a your implicit statement.
We are asking you, you said you will show the facts. What fact is in dispute? The fact they have stated that you have participated in the recruitment process. The fact they have stated you have opted for two groups. That is not in dispute. You have appeared for interview under the both group. That is not in dispute. In group A, you have been selected where there is a composition of 4 members. That is not in dispute. In group B, you have appeared where there is only 2 according to you and 3 according to them, where you have not been selected. No, according to them, there is 3. Their stand is recorded. No, that's not the point. If we have gone through the entire facts for everyone who appears, We need not go through the entire facts. Therefore, we are asking you which fact is in dispute. We will not allow you to place all the facts again which have already been placed. We will not allow you. What are in dispute? Therefore, we are asking you. Yes. Correct. So show us which fact is fabric. Yes. Yes. Yes.
That 622.5 was the equal candidate was selected.
So how does that materially change? That will not change the situation. We are not stopping you. We are asking you to narrow down the scope of the issue being considered. First, you state what facts are in dispute. Tell us which fact is in dispute. Yes.
Compared to the points, they are first of all, they have taken this kind of delay. That there was an inordinate delay I have done. I was late over the matter. So I am not entitled to any benefit.
Yes.
Lord, kindly come to Lord, the paper book, page 2. They say that since 2018 I proceeded in this matter. I applied for RTI. Kindly come to page 2, column 3. I started my value from 2015 to 2024. This was their admission.
That is not their submission. Why are you putting submission which they have not made? They have not said that you made RTI application late. They said although you knew after the reply was given under RTI in 2018, you waited till 23 to file the OA. That is their submission.
They are not that since they have not replied to my query, I had to find first appeal. Then, when first appeal was not disposed of, I went to the commission.
But they have not raised this issue. They are not saying that you have approached the RTI authorities late. They are saying after the RTI authorities gave you an information in 18, you waited till 23 to file the OA. That is what they have said. They are not saying that you have pursued the issue late. Yes. No, in 18 it has been supplied to you. What do you mean? Mr. In 2018 it was made available to you. May 2018. No, you please turn to page 63. Yes, what is the date? Then why you say no? That no, it is not 18. Why did you say? Yes. Yes.
They have replied some of the queries.
Yes.
And thereafter, Lord, you will also come to a 65.
No, this 63 is the reply, sir.
63 is the reply of Lord.
Of RTI.
Yes, Lord.
Of 2018, and you say no, in 2018 it was not replied. Just now you have said not in 2018.
I don't want to say so because he went on filing RTI applications because seeking the information which are required.
Since 2015. You have already said that. He made application since 2015. In 2018, this reply was given to him. He filed OA in 23.
Well, that reply, after that reply, you know, where you also found that some of the queries were not given. The reply was not given.
But this is the only query which you have raised in the OA.
Therefore, thereafter, you do not can come to 65. There is another query. 11/6/2018.
This is also of 18, yes.
Yes, there are the 65 and come 66.
Yes, that is of 19. That is of 19. Yes.
But not because they never replied to that.
Yes, next, what else?
Lord, there are many Lord's equality. When you were not Lord replied when you already some of the queries. Some of the queries were replied to now. Lord has made 71.
Yes.
Before the state information function.
Yes.
They had that too. And then Lord, and it comes to page 72.
Yes.
The facts of the case, I am probably the candidate of the I might no longer serve, so I was called for to serve this pay at you clearly possibilities in the service program that of whereas my comparative explained interview by 440 constituted 22 services.
Yes.
I was interviewed by members along with each member of the board carrying equal marks, that is 50 out of the total interview marks of 200, which is clarified by PSC section 5 number 5 so second so against my question number 8. The members interviewed were awarded individual marks. I scored 8 marks out of 200, and it considerable that the candidate who appeared before the board belonged on the same PSC law, and where below the score was 200, he got 158 marks. Where the full body was there, 4 interviews were there. And there are a lot full body interview of 2 page services headed by C. Shobu Satishay, even 7 gives, whereas I C got 80 marks in the partial interview. Chaired by C of IAS and effective circle the IAS declared due to the absence of other 2 members giving my time only, which can be verified from the authentication of the sourcing of the concerned interviewers. I have been appealing for information since 2015, but the PSC has been providing me either partial information or maintaining uncanny silence without any result. I scored 20 exams in the offices of general faculties, but my passion for service was the police service, as previously I had worked for some years as chief controller jailer in the correctional services West Bengal. In my earlier application dated 11/6/18, I made a prayer for disclosure of certain facts and figures related to the officer P11, which is very much related to me. And where a candidate by two of the service who was appointed on 24/2014 against the first appointment is the difference by earlier member of the service. My prayer has limited pertinence and significance. Then the Lord, tell us what is particular page 74. The order of the commission first order. This first order is not dated 2019. Lord, commission thinks that reply to para 1 and 6 appear as per the act, but denial of information under query 4 has not been justified by the state public information of commission. State public information commission. Commission therefore directs the state public commission to submit a written statement of this commission justifying the denial as stated above. Commission will finally decide the conduct of hearing questions of both the parties in terms of in the court. Then beyond page 75, the order was the last question. are the submissions made by both the parties and of the principle of the record, the commission hereby rejects the ground for critical of information and the SPI will hereby directly provide the information in respect of point number 2 and 4 the appellant within the period of 2 weeks from the date of this order and the recommendation of the commission. That order was passed on 16/11/2021 and thereafter Lord granted notice was served. Then Lord kindly not take submission was addressed to the joint secretary Lord on the service commission appealing the miscellaneous studios and creators joint by the SPI and every secretary public service commission against the honorable West Bengal Information Commission order. In the final order of the honorable dated 26/8/1, item number 4, parties meet the authenticated digital news 4/6 of the selected candidates of the 2011, including myself, against well number 2 and the preference list of the same against well number 4. ITRK later 12 that we informed by a related result that 23/2022 by the SPI that is specific document short form have been digital or by PSC press and that also in a multi-story CQS PSC building sale between item project. As a probability and successful candidate, the official 2011 examination is 28 that I am flabbergasted as the non-balance and accountability of the PSC operating in this respect. To illuminate the authenticity, I would found some information that government features implanted both the press, both the past chairman and secretaries of the PSC in separate petitions. I will particularly focus on my petition dated 15/5/2017 addressed to the Secretary PSC and subjected as reminder of the said circular given in 2016 the lead chairman CS Jeremy officers and he initiated an inquiry into the contents of prayer under the supervision of the Secretary PSC. I made CS Jeremy vice person to help him with clarification of doubts which arose in course of the said inquiry and with prayer of experience. Finally, just before his retirement on my third visit, as summoned by him, he along with the Secretary PSC stated that my score sheet of interview was salvaged and it was authenticated by then Chairman Mr. Muthuwa and 16th October I was retired and the marks and signatures of other two interview expert members were conspicuously absent. So in my presence, see Mr. G. Chatterjee on the file, wrote the file to the Secretary to act as per rules to address the cross anomaly in my interview for police service. In this respect, I will emphasize upon the facts that the concerned sourcing and the preference list which the SPI has irresponsibly stated as digested by press communicated by me as the inquiry that inquiry file of that day. As the rejoinder of the SPI is totally spurious and subversive to the hearing of RTI Act. Moreover, during the final hearing of the Special Information Officer, the SPI was stated in public, which is recorded that both the documents, namely score sheet and the certificates, are preserved. That came out in 2022. His score sheet, wherefore it will appear and it will end the controversy that whether 2 members signed or 3 members signed or 4 members signed. Because I was only candidate who was with 2 members on that day. Because after having taken interview of 4 members, there was a break. And during that time, I was called by the chairman. And I was there only, I gave only 2 members. and I knew both the members who interviewed me. That's why, my lord, in my way application, in all applications, right from 2015, I have pointed out this as well. And my lord, only Mr. Chatterjee, the chairman of the PSC, he without made an inquiry and found that there was some anomaly, so he put an endorsement in the file. But that I have been, Lord, vanished out of. Lord, till now, that file and the endorsement of the PSC chairman was never produced to quality of the Lord, or even before this commission.
In the process for Group B, you are the only candidate who was interviewed by a two-member board. All the other candidates in Group B. No, where is your assertion to that effect? Yes. In which paragraph you have stated? We are reading. Paragraph C. Paragraph C does not say you are the only person. It does not say you are the only person who was interviewed by a two-member board. It says the Group B board was of 2 members. It does not say you are the only person, which you just now submitted. Mr. Counsel, you very well understand what we are saying. And therefore, we are asking you, where is that amendment that you were the only person singled out to be interviewed by a 2-member board? And all others in Group B were interviewed by 4 members. Because this is what you have submitted. There is the question of paragraph 22. Facts of the case start at we hope. What paragraph 21 of what? No, OA. Show us from the OA. Yes, forget about paper book. Where is your specific assertion that you are the only person singled out to be subjected to an interview by a board of 2 members, and all others in Group B, they were interviewed by 4 members. You have just now submitted. We asked you, where is that assertion? Otherwise, it is a factually incorrect submission. So show us from the OA that it was your case. We don't appreciate such submissions unless it is borne from the record. Not at all. We would rather rely on you than to check everything from the brief. We ask you again, where is the assertion based on which you made a, no, you are not, you are reading something else. Where is the assertion that on the basis of which you made a submission that in group B, you were the only person interviewed by a 2-member board? From your OA, you have to show that. From your OA, you have to show that. That you cannot show from there. Either it was your case or it was not your case. So show from your OA. Show from your OA. Don't make factually incorrect submissions. That is a factually unless born from, you should be sorry, sir. You should be sorry, because we would rather rely on what you say than to have to search for everything to verify whether it is a correct submission or not. All right, so it is not there in the OA. Now proceed further. Incorrect submission. Yes, that is known. Other participants in group A, not group B. That is already, that has been told to us. There is no distance. Correct. That is your case. Correct. Correct. That is your case, yes. This is not your case that others in group B have been interviewed by 4. Others in the process have been, that of course, that is your case. Yes. Of? Yes.
So 5 members, they are not discussed while I'm not referred this paragraph also, including the one government when on the higher official this matter was approved, so was asked whether the person belonged to government representative like judicial service. You all have to judge your representatives and you not got your scope of giving marks, you not the expert Director of Police, who represent him is not, because he is representing the directorate. So, my lord, apart from this, that's why this is their my lord statement that actually the report must be of 5 members. Then, my lord, can you see paragraph 23? The petitioner submitted their adverse contents of this services. All the members the interview code of service. There were only 3 members present. Therefore, there was 1 member short in the interview code of service. And thus, respondent number 1 short applying to and consequently increase the marks. Calculation would be of marks obtained by the for this law. That details of the marks obtained by the last respondent candidate and the marks of the respondent number 1
This has already been placed by them. This has
critical calculation which has been presented to will justify that there were 3 members and these of this law table. I will show your lordship that they were right because the 4 members never claimed that they were not interviewed by the full court. They never claimed because their case that were interviewed by the court and they got the marks and not they were appointed in their respective courts.
this table is made by them by way of illustration. Yes. Yes.
Their equal marks of each, total marks was 200.
This is a table for group B.
Group B.
In group
Not group B, these 4 persons were not in group B, only 1 person was not.
Which 4 persons?
Hello, can you see? Personal test number. 1 person got 130. 130 million, 200 marks is allotted for 4 members. And out of that, he got 130. And there were 2 members, and he was interviewed by 2 members. As because of me. Then he would not get this 130 out of 100. This logic your lordship can see.
We are not able to follow, sir. You please have.
Category. Grand total 25 million.
Yes, we have it.
Grand total 622.5.
Yes.
Grand total.
Yes.
Then we got personality test 130.
Yes.
These marks, they have their yes, they have rejected that they got these 2 marks of 2 members.
No. Now they are saying that if a proportionate quotient is to be added, then this will be the marks.
That is the next column. Next column that is proportionate quotient.
Correct.
Because this 130 I am not drawing your lordship's attention that will not your lordship's is an admitted position that every member has got equal marks.
Yes, obviously, yes.
20 each, 4 members.
Yes.
So will not this and 80 is not 130 of the content. It is 4 members. And next one, he got 120 of the content. It is 4 members.
Yes.
Then we got another candidate 110
Yes.
of the 4 members. Then we got 100 of the 4 members. Then we got how can we got the claim? How can they claim that they are also equal? They average marks. The proportionate quotient is here is the equal that is my question for the marks that I answer. Lordship, that they are making a big outlay in this case. Because whatever chart we have shown, and your Lordship was striking. Grand total 22, including personality test and executive that practical marks, that 66 to 2, last one 73. And this is most funny. Otherwise, you are proportionate quotient of the basis of the marks you are to receive in written examination. What you got 492.5. And along with that, we have 173 that is added in to come. But they have made this analysis, this calculation project that our guide your way or petitioner, where these 4% are also equal. Entirely will not be very big of the order of the tribunal. How can that be?
According to them, in the Group B interview board, there were 3 members. They have not admitted to your allegation that there were only 2 members. Now first, because you referred to this table, therefore we are asking you. You are trying to discredit it on the premise that there are only 2 members. They don't admit to that. They say there are 3 members. Therefore, this submission that you are making is on your basis of your case. We hope your conference is over. Sir, this is not your conference chamber. What are you doing and what is he doing? Yes. Yes.
Can you see that even if they were not
What is the second table? I am not able to understand. The details of marks obtained by the last recommended candidate and the marks of the respondent. 1. So, how it can be? Yeah. Yeah. All right. Yes. This is by way of their projection. This is not the actual position. Correct. That is under the heading PT. That is under the heading PT. That is the actual marks. GT is. Oh.
And they have taken that grand total and is the proportionate pocket.
Correct.
And jumped upon this figure. And they are saying it's not logical.
That is not the point. The point is, whatever they may be their projection, whether you are entitled to such a direction, that is the issue. That is not the issue. Yes. 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 Not you. Where candidates under Group B were interviewed by 2 members. That unless you make that assertion, we will not call upon them to refute that. Unless you have made that assertion, why should they be called upon to say that?
They have said if I got the proportionate mark, then these
All right.
candidates
Very well. Now what else? Tell us.
from that Milord, they are also entitled.
All right. What else? Tell us. Neither you have stated so, nor the tribunal's order records any such fact, and you are making a submission. Yes, what else? What else? Tell us. Yes. Sir, whether 2 or 3, that is immaterial. Even if it was 2. Yes. No, from but where is this assertion? That is what we are asking you. All right. All right. Yes, 106. What do you want to show? Yes.
Say applications are matters of record.
Yes.
Contention of petition applicant. 18 paragraph 6, million 60. And exactly happened.
Yes. All right.
My lord, then my lord, is 118. The government's observation, after hearing the submission to the advocate representing the respective parties, of releasing the available records in the undisputed fact that the applicant got 512 marks in the written examination and got 1 marks in the personality test of these services. The dispute is regarding the quorum of the personality test.
Do you dispute that you were awarded 152 marks in the personality test? You got 158. 158 could have been awarded by 2 members. Huh? Okay. And what is the personality test marks in group B? Your marks? 80. All right. Yes.
Lord, that sports is my lord, the candidate and me as this my lord an opportunity to see this course which was not produced either even if your lord's inquiry that they take this.
Yes. Complete this. Complete this.
Then my lord, the quorum for the personality test for the services of 5,030 attention of Mr. Ryan and senior advocate of the original application, the applicant had given his acknowledgement had stated that there were only 2 members, that is, of the chairman of the commission and instead of the required 4 members to form a group. Then Lord, there is Lord and Lord, if this force is Lord, Lord, government, if we control us, because that is the original Lord record. If they have Lord suppressed so long, Lord, that will end the answer. Whether I am entirely supposed to protect that is average marks. Average marks has been Lord indicated in the rules and procedure. The laws by law, you must procedure provided that average marks and the RTA applications required.
We cannot continue today. To continue tomorrow, Monday, as prayed by